Sound check, level 1-0 testing. Testing, Chairman Scott's mic, level 1-0 testing.
We have a, how's the quorum looking? How's the quorum look? Do we have a quorum?
Don't worry on mine. I mean, I
Do we have a quorum? Committee will come to order, a quorum being present. The committee meets today pursuant to notice to consider H.R. 1230, Protecting Older Workers Against Discrimination Act, of Powota, the H.R. 1309, the Workplace Violence Prevention for Healthcare and Social Service Workers Act, and H.R. 397, the Rehabilitation for Multi-Employer Pension Act, also known as the Butch-Lewis Act. Chair announces that any request for recorded votes may be rolled pursuant to Clause 2, Rule 11 of the Rules of the House of Representatives and Committee Rule 13B. Pursuant to House Rule 11, Clause 1, the chair may recess at any point. I now recognize myself to make an opening statement. Today, the committee is considering 3 bills that will protect the dignity, income, security, and safety of workers and retirees. The first bill before us, H.R. 1320, the Protecting Older Workers Against Discrimination Act, or PWOTA, will improve the lives of American workers by restoring protections against age discrimination in the workplace. Since the 1960s, Congress has recognized the federal government's responsibility to ensure that older workers are not forced out of their jobs or denied work opportunities because of their age. Unfortunately, a 2009 Supreme Court decision increased the burden of proof needed to successfully challenge workplace age discrimination, making it harder for victims to achieve redress. This bill restores the pre-2009 evidentiary threshold for age discrimination claims and aligns the burden of proof with standards applied to discrimination cases based on sex, race, religion, and national origin. Second bill we'll consider today, H.R. 1309, the Workplace Violence Prevention for Healthcare and Social Service Workers Act, will protect our nation's caregivers from workplace violence. Research shows that healthcare and social service workers suffer injuries from workplace violence at far higher rates than other workers. According to the Government Accountability Office, workplace violence is a serious concern for approximately 15 million healthcare workers in the United States. Unfortunately, OSHA has not been given the tools to ensure that workers are adequately protected. OSHA does not have a standard that requires employers to implement workplace violence prevention programs. They have a voluntary guideline program. The data show that voluntary efforts alone are not working. The rates of serious injuries to our nation's caregivers from workplace violence is rising nearly every year. The Workplace Violence Prevention for Healthcare and Social Service Workers requires OSHA to implement a standard requiring healthcare facilities and social service providers to develop and implement a workplace violence prevention plan. The third bill before us, H.R. 937, the Rehabilitation for Multi-Employer Pensions Act, known as the Butch-Lewis Act, will address the multi-employer pension crisis and ensure that hardworking Americans can retire with dignity and security. While most of the 1,400 multi-employer pension plans in the United States are not in any danger of collapse, roughly 130 plans, which cover over 1 million participants, involve thousands of employers across the country, are currently projected to collapse within 20 years. Some will be insolvent far sooner. If Congress does not intervene to stop these collapses, a wave of retirees will be forced to rely on taxpayer-funded social safety net programs. Participating employers will have to cut tens of thousands of jobs, and employers will continue to suffer from costly and growing withdrawal liability, which is already impairing their access to credit, increasing the cost of borrowing, and undermining their ability to grow. So this is not a problem of tomorrow, this is a problem of today. Allowing multi-employer system to collapse will cost taxpayers hundreds of billions of dollars. In other words, doing nothing to address this crisis is the worst and most expensive option we have. The Bipartisan Rehabilitation for Multi-Employer Pension Act will help mitigate the multi-employer pension crisis by financing loans for eligible multi-employer pension plans that need the most help. Simply put, this bill will protect retirees' pensions without cutting back on benefits. This bill was originally named for Butch Lewis, a retired truck driver from Ohio, who was a leader in this fight to protect pensions and who passed away more than 3 years ago at the age of 64. We're honored to be joined by his wife, Rita Lewis, and many other retirees and advocates who have traveled great distances to be with us today. 3 bills under consideration this morning reflect our commitment to ensuring that all Americans should have access to safe workplaces where they can work free from discrimination and retire with dignity. I encourage all members to support these bills. And now I yield to the distinguished ranking member from North Carolina, Dr. Fox, for her opening statement.
Thank you, Mr. Chairman. Thank you for yielding time. Faithful fans of this committee who attend in person or enjoy watching the proceedings online seem to be getting, that have noted that our opening statements seem to be getting longer and longer. Mr. Chairman, the time is yours to control, and you are generous with it. You and I are passionate about many of the issues under this committee's jurisdiction, and naturally, as a result, have much to say. I believe that's good for the process, good for bipartisanship, and it's good for informed debate. But I hope no one here conflates all that talking with actually doing our jobs. We shouldn't have to explain what a bill does in our opening comments. By the time we reach markup, the committee should be so well versed in the issues before us that we can get right down to business, but that's not the case today. If we're to begin with H.R. 1230, the Protecting Older Workers Against Discrimination Act, we need a little more context. In a hearing that was billed as, quote, barriers to employment, end quote, just a few weeks ago, this piece of legislation was one of 5 that committee Democrats tried to market as inhibitors to employment, ignoring the chief barrier to employment, which everyone here knows is still lack of skills for in-demand jobs. Nevertheless, we heard from a single witness about this bill, one of the 3 that the Democrats invited. Unfortunately, committee Republicans were allowed to invite only 1 witness to cover the many hearing topics included by the Democrats. Democrats, because the hearing was so broad, had only 1 witness prepared to address this particular issue. That single Democrat invited witness, however, was extremely informative. Lori McCann from AARP told us in her written and spoken testimony, for several reasons it is difficult to quantify the impact that the Gross decision has had on the number of older workers who bring cases and the number of those who win them. In other words, the evidence base for H.R. 1230 isn't there, and the Democrats' own people are admitting it. Lacking reliable evidence and lacking a full hearing on the issue or the legislation, we are nevertheless here to consider yet another bill that amounts to nothing more than another trial lawyer payday. When it comes to federal authorizations and appropriations, we often use the term funding streams. It seems committee Democrats are looking for very specific funding streams to ensure payouts to trial lawyers who specialize in particular client groups. Earlier this year, committee Democrats made special provisions to trial lawyers who profit from women, and in this markup, they have chosen trial lawyers who profit from older American workers to secure their own personal funding streams. Taxpayers are still on the hook for these funding streams, no matter what, because as we all know, employers are taxpayers. Continuing their rush to keep up with this committee's and the House's remarkable record of haphazard legislating, committee Democrats have put forward H.R. 1309, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. In our single hearing on this issue back in February, members on both sides expressed a desire to work together to produce meaningful and effective policy. Instead, committee Democrats have unilaterally decided to advance legislation that rushes the rulemaking process and short-circuits valuable input from people who know better than we how to prevent workplace violence in these unique circumstances. But the most stunning turn of events has been the announcement that we would, in fact, proceed with consideration of a full taxpayer bailout of private sector multi-employer pension plans. When this markup was noticed in this particular bill, H.R. 397, was listed, I, along with every member of this committee who understands how serious and complex this issue, was shocked. Lining this room are the portraits of individuals who served as chairs of this committee, Democrats and Republicans alike, going back several decades. All of them have managed the committee's vast and varied jurisdiction with an all too clear understanding that the issue of pension reform is one of the most difficult, high-consequence responsibilities that committee members must meet. That is why, regardless of party affiliation or other pressing circumstances, they insisted that this committee proceed with extraordinary care, caution, and cooperation before touching the retirement security of so many hardworking Americans and retirees. They would be confounded by today's markup. We're actually about to consider a bill that is poorly drafted and outlandishly framed. In 2014, many of us on this dais today, under the leadership of Chairman John Klein and Ranking Member George Miller, worked together to bring much-needed reforms to the multi-employer pension system with an understanding that no amount of money would fix the structural problems in the system that put so many retirees and taxpayers at risk in the first place. The legislation before us today totally destroys that framework. It is a sweeping, politically motivated ploy that is beneath the standards and the integrity of this committee, which is historically modeled for the rest of the Congress in practice and in policy how we should treat something so personal and so vital to Americans as their own hard-earned pensions. This isn't just a taxpayer bailout. This is a lie. We're here to consider a bill that will meet certain death in the Senate. We'll find ourselves back at the drawing board, and everyone here knows that what we can expect on an issue as complex as this one, those of us on this committee who were here in 2014 will recall the serious bipartisan negotiations required to get a final product on which we could all agree. And those of us who served on the Joint Select Committee established during the last Congress to focus exclusively on this issue know it's not this easy. If it were, the Select Committee would have reported a bill. But the workers and retirees are going to be impacted don't see it that way. They see Washington Democrats offering more false hope. They're told by one special interest group or another that all we have to do is spend $100 billion of the taxpayers' money and they'll be fine. Their pensions will be secure and they can rest easy again. We know that's not true. We owe it to them to take this problem seriously. This bill is not serious, and treating unserious proposals as real solutions amounts to lying to the public. I've yet to see anyone who truly needs answers, who truly needs help, benefit from these empty promises. Democrats make lavish promises to students, to seniors, to hardworking mothers, to hourly workers, and here now to retirees. And the only people I've seen ever benefit from these empty promises are Democrats themselves on Election Day. On behalf of every American who will be left empty-handed today, we will continue to be truthful about what we're doing. We will continue to search for real solutions instead of shortcuts and paybacks to special interest. Talk is cheap. Bad bills are costly. Mr. Chairman, in the interest of time, I yield back.
Without objection, all members who wish to insert written opening statements to the record may do so by submitting them to the committee clerk electronically by the end of the day. House rules require that a copy of measures to be made available to members and the public at least 24 hours in advance, since we're using an amendment roster pursuant to Committee Rule 12E and is discussed in the committee's organizational meeting and pursuant to today's notice for meeting. A copy of these measures were made available to members and the public at least 48 hours in advance, and priority will be given to amendments submitted to the committee at least 24 hours in advance. This means that for each bill being marked up today, the committee will use the amendment roster. The bill shall be open to amendment at any point, and will take up amendments in the order listed on the roster. The chair will allow members to offer amendments listed on the roster out of order to the extent practicable and in a manner not prohibited by House or committee rules. Amendments not listed on the roster will be considered at the conclusion of the consideration of the roster. Additionally, the chair may allow members who have more than one amendment to offer amendments en bloc to the extent practicable if necessary. The committee now will proceed with consideration of the bill, H.R. 1230, for amendment. The bill was circulated in advance and printed copies are available. The clerk will designate the bill.
H.R. 1230 to amend the Age Discrimination in Employment Act of 1967 and other laws to clarify appropriate standards for federal employment discrimination and retaliation claims and for other purposes.
Without objection, first reading of the bill is dispensed with. Without objection, the bill will be considered as read a second time and open for amendment at any point. Any amendment offered shall be considered as read. I now recognize myself to offer an amendment in the nature of a substitute. The clerk will designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 1230 offered by Mr. Scott of Virginia.
Without objection, the amendment shall be considered as original text and open for amendment at any point. The amendment in the nature of a substitute has already been distributed. And I now recognize myself for 5 minutes to explain the amendment in the nature of a substitute for H.R. 1230, Protecting Older Workers Against Discrimination Act, WOTA. I'm proud to sponsor this legislation along with my Republican colleague, Representative Jim Sensenbrenner from Wisconsin. I want to also recognize the committee members from both sides of the dais who have co-sponsored the legislation. In 1967, Congress enacted the Age Discrimination Employment Act, or ADEA, to promote the employment of older workers and to prohibit discrimination based on age in the workplace. Specifically, ADEA protects workers aged 40 and older from being forced out of jobs or denied work opportunities because of their age. It was passed along with other landmark civil rights acts, including the Equal Pay Act of 1963 and the Civil Rights Act of 1964. However, the case Gross v. FBL Financial Services, the Supreme Court in 2009 upended decades of precedent by heightening the evidentiary threshold previously applied under ADEA claims, thus making it harder for older workers to prevail in age discrimination cases. The 5-4 decision requires plaintiffs to demonstrate that age was the, quote, but for or sole motivating cause of the employer's adverse action. Previously, it was sufficient to prove age was one of a number of factors behind the employment decision under the mixed motive framework that has been in place up to that point. In its May 21st, 2019 legislative hearing, the committee learned that in addition to hurting individual workers who have been treated unfairly, the Gross decision sent a message to employers and to courts that age discrimination wasn't as wrong or unlawful as other forms of discrimination. Under the Gross decision, as long as an employer can point to other lawful motives that may have played a role in the adverse decision, employers were not held liable or accountable even in cases of overt age discrimination. As AARP pointed out, and I quote, "In this matter, the Gross decision undermined Congress's entire purpose, mandate, and expected enforcement of the ADEA, that discrimination played no role in employment decisions," unquote. WOTA is limited and straightforward in its restoration of the causation standard that was in effect when consistently applied by the courts before the Gross decision. It also addresses the Supreme Court's misplaced extension of the evidentiary test in Gross decision to the anti-retaliation provisions of Title VII of the Civil Rights Act in 2013, as well as to disability cases in numerous lower courts. So the Board will amend 4 civil rights laws: the ADEA, Americans with Disabilities Act, the Rehabilitation Act of 1973, and the anti-retaliation provision in Title VII of the Civil Rights Act of 1964. Legislation reinstates the mixed motive test for age discrimination claims, the standard currently applied to discrimination cases involving sex, race, religion, and national origin. This means that victims of discrimination will not have to demonstrate that age was the sole decisive factor in the employer's action in order to prove their case, only that the unlawful discrimination was a contributing cause to the adverse action. Without this bill, a victim can obviously prove age discrimination and still lose the case because the victim could not show that other factors were not in play. The bill also clarifies that workers may prove discrimination by any form of admissible evidence. The amendment nature of substitute retains the core provisions of H.R. 1230 as introduced, but eliminates the bill's findings and purposes in the interest of simplicity and adds a severability clause. As research demonstrates, age discrimination in the workplace remains pervasive. 3 in 5 older workers report that they have seen or experienced age discrimination on the job. Discrimination is discrimination. And this bill will make Congress's intent clear that no amount of unlawful discrimination in the workplace is acceptable. Older workers should have the same protections afforded to other classes of people under Title VII of the Civil Rights Act, and so I urge my colleagues to support this bipartisan proposal, and now yield to the ranking member for her statement on the amendment in nature of a substitute.
Thank you again, Mr. Chairman, for yielding. Every American should be protected from discrimination at his or her job. Older Americans in particular face unique challenges as they continue to make invaluable contributions to the workforce. This bill not only fails to protect them, it probably would inevitably cause more harm than good. It is the same old cookie-cutter approach that shows a lack of consideration, collaboration, and critically, a lack of acknowledgement of legal realities and implications. Unfortunately, committee Democrats have chosen to push their pro-trial lawyer agenda by putting forward legislation that masquerades as a protection for a specific group of workers. This bill is yet another one-size-fits-all approach which fails to address a purported problem and which disregards real-world experience in the workplace and decades of Supreme Court precedent. This strikes me as unhelpfully arrogant. H.R. 1230 will increase frivolous litigation, reducing the available resources intended to address discrimination in the workforce. In 2013, Supreme Court Justice Anthony Kennedy wrote in his majority opinion in the Nassar case that allowing mixed motive claims in Title VII retaliation cases, as H.R. 1230 does, quote, could contribute to the filing of frivolous claims which would siphon resources from efforts by employers, administrative agencies, and courts to combat workplace harassment, end quote. Also, as H.R. 1230 cases will increase litigation and cost, only trial lawyers will benefit. And under this bill, a plaintiff is highly unlikely to receive any monetary award from the defendant. Only the plaintiff's lawyers will reap the financial rewards. I'd like to believe this harmful proposal is an oversight and misunderstanding on the Democrat side and not intentional pandering to a specific special interest group, in this case trial lawyers, and not older American workers. Congress purposefully enacted separate non-discrimination statutes, including the Age Discrimination in Employment Act, because, as multiple Supreme Court decisions have affirmed, age discrimination involves unique and complex factors. In 2008, Supreme Court Justice David Souter wrote in his majority opinion in Meacham v. Knowles Atomic Power Laboratory, as we have said before, Congress took account of the distinctive nature of age discrimination, end quote. H.R. 1230 abandons these important precedents which will harm, not help, older Americans in the workforce. In developing H.R. 1230, not only did this committee skip holding a hearing solely dedicated to it, but the only witness discussing the topic, who was invited by the Democrats, testified about the bill at a general hearing entitled, quote, "Eliminating Barriers to Employment," end quote, and even acknowledged that we do not know what the impact of the Supreme Court's decision in the Gross case has been. She said in her testimony, quote, "For several reasons, it is difficult to quantify the impact that the Gross decision has had on the number of older workers who bring cases and the number of those who win them," end quote. Like other legislation before it, H.R. 1230 has been rushed through this committee without thorough discussion or consideration. This bill begs for reliable data and evidence, thoughtful deliberation, and genuine consideration for every older American in the United States. If we really want to eliminate discrimination, and we all do, we must ensure non-discrimination statutes allow workers to remedy unlawful discrimination effectively. But H.R. 1230 does not do this. It does nothing to improve our non-discrimination laws and will not help older workers. The bill's title and provisions are yet another case of false advertising and empty promises. On behalf of every older American worker who deserves better than lies and false hopes, I urge my colleagues to vote no on this deceptive piece of legislation. Thank you, Mr. Chairman. I yield back.
Thank you. Are there other members that wish to be recognized? Gentlelady from Oregon.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
Thank you, Mr. Chairman. Americans are living and working longer, and we must do all we can to make sure they're protected from age discrimination. According to recent data from the Census Bureau and the Bureau of Labor Statistics, the percentage of retirement age Americans in the labor force has doubled since 1985, and unfortunately, age discrimination in the workplace is still disturbingly pervasive. According to an AARP survey released last year, 3 in 5 older workers reported seeing or experiencing age discrimination on the job. My home state of Oregon has one of the most rapidly aging populations in the country. I've heard from workers, particularly those in the technology industry, who believe they have been dismissed or denied employment because of their age. Unfortunately, age discrimination is a significant factor in long-term unemployment of older workers. According to a study from the Urban Institute and ProPublica, 56% of older workers over the age of 50 are pushed out of long-time jobs before they choose to retire. And only 1 in 10 of these workers earns as much as they did before their involuntary separation. Investigations by the U.S. Equal Employment Opportunity Commission often take years to complete, and still discrimination is often very challenging to prove. In 1967, Congress passed the Age Discrimination in Employment Act, or ADEA, to prohibit age discrimination in the workplace and promote the employment of older workers. But in 2009, the Supreme Court's decision in Gross versus FBL Financial Services imposed a much higher burden of proof for workers to prove age discrimination than had existed before. I joined Chairman Scott in reintroducing the Bipartisan Protecting Older Workers Against Discrimination Act. The bill is an important step to protect older workers from discrimination in the workplace. It would amend our 4 core civil rights laws, ADEA, the anti-retaliation provisions of Title VII of the Civil Rights Act, the Americans with Disabilities Act, and the Rehabilitation Act of 1973, to make congressional intent clear. Unlawful discrimination in the workplace is unacceptable. This bill is a product of bipartisan negotiations, and the amendment in the nature of a substitute makes minor technical changes. Ageism is entrenched in our culture, but today we can make sure that older workers who are striving to provide for themselves and their families will have their civil rights protected. We can do that by supporting the Protecting Older Workers Against Discrimination Act. And Mr. Chairman, as a former trial lawyer myself, I just want to note that, as Representative Wild has noted in the past, people who take cases like this do so after a thorough analysis, and they take the case in order to help the worker assert their rights, not for their own benefit. Mr. Chairman, I request unanimous consent to enter into the record reports on the prevalence of age discrimination in the workforce from Associated Press, NORC Center for Public Affairs Research, United Income, and ProPublica, and the Urban Institute.
Without objection.
Thank you, Mr. Colleague. I urge my colleagues to support this amendment in the nature of a substitute, and I yield back the balance of my time.
Thank you. Do other members wish to be recognized? Gentleman from Wisconsin, Mr. Grothman.
Yeah, I just have a few comments or concerns, and I'm not on the subcommittee that dealt with this, but I'm co-sponsoring this bill because I think it's absurd that we would consider, which we are right now, age discrimination is less of a problem than the other sorts of discriminations. That being said, one problem that is not being taken up, but I want the chair to be aware of, is I think whenever you have a protective class, first of all, usually claims are made under this sort of thing when somebody gets fired. Okay, that's age discrimination, race discrimination, anything. And usually the majority of those claims, a vast majority, are shown to be not meritorious. As the result, I think sometimes what happens is business looks to avoid hiring protected class people because it makes it more difficult to fire them, and knowing that it'll be more difficult to fire them, the way they deal with it is they don't hire them in the first place. I'm not sure how to deal with that, but I want the chair to be mindful of it, and I don't know what we can do to protect that in the future. Part of the problem on all of these claims is, well, it's possible to be sanctioned for filing a frivolous claim. As a practical matter, either nobody or almost nobody is. So those are things I throw out there for the chairman or subcommittee to look at eventually. And like I said, I'm co-sponsoring the bill because I just think it's age discrimination is just as important as other these discriminations, but I want the chairman to be aware of sometimes inadvertent problems that can arise from this.
Will the gentleman yield?
Sure.
You mentioned a sanction for filing a frivolous case. Most of these cases are taken on a contingent fee. So if you file a frivolous case that you're not going to win, you get sanctioned because you don't get paid. Is that right?
At least in Wisconsin, I would say the majority of discrimination claims are filed even without the assistance of a lawyer.
Thank you. Gentleman yield.
And I'll go a little further. The problem is they're filed. Frequently, the business feels compelled to hire a lawyer, and that's why you wind up having people settle for a given amount of money because they don't want to go through the system.
Gentleman yields back. Gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chairman. I move strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I speak in strong support for H.R. 2030, protecting older workers against discrimination. I support the bill because it restores the original spirit of the Age Discrimination in Employment Act. In an era where Americans are working harder than ever just to get ahead, they're also working longer. Americans age 65 and older are our fastest growing age group, and as the baby boomers get older, their presence in the workforce will only increase. Yet they and even workers a generation younger are frequent victims of age discrimination. The numbers tell the story. More than 6 in 10 workers aged 45 and older say they've seen or experienced age discrimination in the workforce. 90% of those workers say age discrimination is somewhat or very common. And more than 3 of 4 workers, older workers, believe that their age is an obstacle to finding a job. This discrimination has terrible impacts on the financial status of our older workers as well as their families. Older Americans are proven to endure longer unemployment periods than their counterparts, and they're frequently subject to pay cuts when they are reemployed. Age discrimination also can cause shorter lifespans. A forced retirement has been proven to lead to declines in mental and physical health. Today, with passage of H.R. 1230, we speak with a strong, clear voice that discrimination has no place in the United States. In 2009, the Supreme Court in the Gross decision basically ruled that age discrimination is less important, less of a problem than other forms of disparate treatment. But what else could you take from a decision that holds proving age discrimination to be a heightened standard? H.R. 1230 will return us to the motivating factor standard test that existed for 40 years, and it will hold unscrupulous employers to account. No one should be denied a job based on stereotypes in our society. Age does not determine an employee's ability or commitment to getting the job done. So I urge support of 1230, and I yield back the balance of my time, Mr. Chair.
Gentlelady's time has expired. Gentleman from Tennessee, Dr. Rowe.
Thank you, Mr. Chairman. I agree with Dr. Adams that discrimination of any type has no place in today's society. But just a few uplifting. We heard this information about how badly senior citizens are doing. I looked up the data last night, and in February of this year, 20% of folks over 65 are working, which is the highest it's been in 50 years. Whereas in 1985, 10% of people over 65 had a job. And by 2024, there are going to be 13 million people over 65 working, over half of whom have a college degree. And this is inflation adjusted. This is the good news. In 1985, that average income was $48,000 a year. Now it's $78,000 a year. So many seniors who are working because they want to and because they're doing very well in today's economy. We have 7.5 million jobs that are unfilled. And I can tell you right now in my district at home, there's some of the senior citizens are some of the best, me being one of them, are some of the best workers out there. They have been used to showing up on time, working hard, being there, being a great employee. So I'm giving a shout out for those 20% of people who are over 65 who've chosen, for many reasons, to go ahead and continue their employment. And with that, Mr. Chairman, I yield back.
Thank you. The gentlelady from Florida, Ms. Wilson.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
I strongly support H.R. 1230, the Protecting the Older Workers Against Discrimination Act. It seems obvious that all Americans, regardless of age, skin color, culture, or any reason, should be able to go to work without facing discrimination. Yet, unfortunately, age discrimination in the workplace is still disturbingly pervasive. According to AARP, it is estimated that as many as 3 in 5 older workers report they have seen or experienced age discrimination on the job. In addition, nearly 2/3 of women and more than 3/4 of African American workers age 45 and older say they have been or experienced age discrimination in the workplace. It seems apparent that age discrimination in the workplace and ageism in our nation continues to be excessively widespread. The Protecting Older Workers Against Discrimination Act will take us a giant step forward towards protecting older workers. It does so by strengthening protections against older American workers in the hiring process. It also ensures that victims of age discrimination do not have to demonstrate that age was a critical reason for the employer's action in order to prove their case in a court of law. For this reason, older American workers will be ensured that there are no additional barriers against them if they decide to make a discrimination claim. I yield back the balance of my time, and I urge my colleagues to support this bill and protect older American workers.
Thank you. Gentlelady from Pennsylvania, Ms. Wild.
Mr. Chairman, thank you. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you. Jack Gross joined FBL Services right after graduating college in 1971. He worked his way up through the ranks of the company as one of its highest performing employees and spent virtually his entire career with FBL, devoting himself only to its success. In 2000, he was demoted for the first time. In 2003, he and all other employees in his department over the age of 50 in supervisor positions and above were demoted on the same day. Mr. Gross took his case all the way to the United States Supreme Court, which ultimately ruled that anyone bringing an age discrimination case under ADEA must prove that age was the but-for cause, meaning the sole determining cause of the employment decision. This misguided ruling failed to deliver justice for Mr. Gross. It sent a message of impunity to employers looking to discriminate on the basis of age, and it set a precedent for denying justice to workers across our country who have been discriminated against because of their age. Workers like Mr. Gross, who have experienced the indignity of workplace age discrimination, are just asking to be treated fairly. Taking the long trip to the courthouse steps is a profoundly lonely, challenging experience. Claimants are ostracized at their workplaces, and they open their lives to invasive probes by defense counsel through written discovery and by deposition. These probes are often meant to embarrass rather than seek the truth. And when our older workers finally reach the courthouse door, it is often locked. We should condemn employment discrimination in every form it takes. Yet our employment laws treat age discrimination differently than other employment discrimination claims. This causes a chilling effect both in the number of legitimate claims pursued and the ability to find an attorney. Studies show that most older workers have seen or experienced age discrimination, but only 3% report making a formal complaint. H.R. 1230, the Protecting Older Workers Against Discrimination Act, will restore equal access to justice for those who have suffered age discrimination. It will create uniformity among our laws that a claimant need only bear the burden of proving that age discrimination was one of any number of motivating factors for an employer's action. Mr. Gross traveled here to Washington to observe the hearing on this bill. I don't want to let him down. I don't want to let down the 56% of workers over the age of 50 who are pushed out of long-time jobs before they choose to retire. During his testimony before the Senate Help Committee in 2010, Mr. Gross said, "I hate having my name associated with the pain and injustice now being inflicted on older workers because it is nearly impossible to provide the level of proof now required by the court." We can right this wrong. We can ensure that Mr. Gross's name will instead be associated with the principles of justice and equality under the law. I urge a yes vote on H.R. 1230. Thank you, Mr. Chairman. I yield back.
Thank you. The others wish to be recognized. Gentleman from Alabama, Mr. Byrne.
Yes, Mr. Chairman, I yield to the gentleman from Wisconsin.
Gentleman's recognized for 5 minutes, yields to the gentleman from Wisconsin.
Yeah, we'll just do it in 30 seconds. One thing I would ask, I mentioned before, I think one thing that can cause discrimination is people are afraid to hire people because they're afraid eventually they'll be afraid to fire them. I'd like to ask you guys to look into the appropriate bureaucracy and report back on the percent of claims, not just age discrimination, but claims on race discrimination or religious or whatever, that are deemed credible. Because I think the vast majority are not deemed credible, which means that would be an indication that a lot of borderline frivolous claims are being filed. And I think it would be illuminating for the committee to know that. Thank you.
Gentleman's time has expired. Are there others that wish to speak on the amendment nature of substitute? If not, there being no further discussion on the amendment nature of substitute, the committee now moves to amendments. Apparently there are no amendments have been offered by on the roster. Are there other amendments?
Mr. Chairman, I have an amendment at the desk.
Gentleman from Pennsylvania has an amendment at the desk. Gentlelady from Oregon.
Mr. Chairman, reserve a point of order.
Point of order is reserved. We're distributing the amendment. Gentleman from Pennsylvania is recognized for 5 minutes.
Thank you, Mr. Chairman. Every American worker should be protected from discrimination in the workplace. On that, I think we all agree. Particularly older Americans face unique challenges as they continue to make invaluable contributions to the workforce, and we should work to help them when they are discriminated against. However, H.R. 1230 will not achieve these goals. It will not achieve the goals espoused by the bill's sponsors. Will rather help the trial lawyers more than they will older folks. This amendment adds some much-needed truth in advertising to the bill. The amendment adds a finding to H.R. 1230 pointing out that under the bill as written, many successful plaintiffs will not be entitled to any monetary damages, payments, or reinstatement. The Supreme Court in the 2009 Gross case eliminated the defense that allows the employer to demonstrate that would have taken the same employment action in the absence of the impermissible factor, such as age. H.R. 1230 restores that employer defense. An overwhelming majority of employers will be able to make that demonstration, and when they do, a plaintiff will not be entitled to any monetary damages, payments, or reinstatement. Only the employee's attorney, in that case, will be paid. The only party who wins in these cases are the trial lawyers. H.R. 1230 is specifically written to allow plaintiffs to survive a summary judgment motion that would end their case, but a plaintiff is in for a surprise later when he or she receives no monetary damages and the only one getting paid is his or her attorney. To add insult to injury, the employee may have to pay income taxes on the fees that are awarded to the attorney. The bill and its sponsors never explain how adding provisions that include mixed motive claims and restoring the same action employer defense will benefit employees. And in fact, as I said, this provision will only help trial lawyers. So I ask my colleagues to vote for this amendment to help clarify the unfortunate consequences of enacting this bill. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. This amendment offered by my colleague from Pennsylvania, inclusive of a finding, is a terribly misleading amendment. It is also highly speculative. Let me first say that I offer these comments as a former litigator who has represented both employers and employees. These are terribly difficult cases to win. The goal of this bill is to ensure that deserving claimants receive justice. The ADA, Title VII of the Civil Rights Act, and the Rehabilitation Act allow for reasonable attorney's fees to be paid when unlawful discrimination is proven, period. Except in limited circumstances, no award means no attorney's fees. The limited circumstances I speak of are that if the employer shows they would have taken the same adverse action, notwithstanding the unlawful discrimination, injunctive relief may be available, which would not result in damages to the claimant, but reasonable attorney's fees can be paid in such case. This is important because it provides a remedy for all employees against an employer who engages in such conduct. Damages can be awarded if the employer cannot show they would have taken the same adverse action given the proof of unlawful discrimination. Even if employers can sustain their burden under a mixed motive claim, their unlawful discriminatory conduct would be subject to injunctive and declaratory relief, and that merits payment of attorney's fees. This amendment, inclusive of a finding offered by my colleague, is speculative, confusing, and adds no value to this bipartisan bill, nor does the amendment strengthen protections for workers. I urge a no vote on this amendment.
The gentlelady yield.
Yes.
Yes, I just want to point out that under the Medicaid and Medicare programs, the beneficiaries get no money, only doctors and hospitals. But they get paid for their services, just like lawyers in these cases get paid for their services. There's nothing wrong with that. And so I would hope that the amendment would be defeated. The gentlelady's time has expired. The other comments? Gentleman from Alabama.
Thank you, Mr. Chairman. I too tried these cases in my career as a lawyer on both the plaintiff's side and the defendant's side, and I do not find this amendment to be misleading, speculative, or confusing. I think it is a correct statement of the law, and I think it's important to tell the public what this bill would actually do. The truth of the matter is that putting a mixed motive provision in here will in fact mean that plaintiffs who are successful in mixed motive cases will not get any damages. They will get nothing. Their lawyers, however, will get paid. So that's really what this is all about, trying to get more money for plaintiffs' lawyers, not the first bill we've had in this committee. So I do want to say that I support this amendment. I think it's an accurate statement of where we are on this bill, and I appreciate the gentleman bringing it forward, and I yield back.
Other comments? If not, questions on the amendment. All in favor of the amendment will say aye.
Mr. Chairman,
Whoop.
I withdraw the point of order.
Thank you. The point of order is withdrawn. Questions on the amendment? All in favor of the amendment will say aye. Aye. All opposed will say no. No. Noes appear to have it. The noes have it. Request for a recorded vote pursuant to previous comments that vote will be rolled. Are there other amendments? Gentleman from Georgia.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment offered by Mr. Allen to the amendment in the nature of a substitute to H.R. 1230.
Mr. Chairman, I reserve a point of order.
Oregon is reserved a point of order, and we'll delay briefly while the amendment is being circulated. Gentleman is recognized for 5 minutes.
Proponents of H.R. 1230 claim that the Supreme Court's decision to Gross 2009 and Nassar in 2013 have harmed workers who have faced age discrimination or unlawful retaliation. This amendment states that before H.R. 1230 goes into effect, the Government Accountability Office must do a study and report to Congress on whether, after decisions in Gross and Nassar, individuals have been discouraged from filing age discrimination or Title VII retaliation charges from EEOC and from filing lawsuits, and whether there have been fewer plaintiffs winning age discrimination and Title VII retaliation lawsuits. If individuals have not been discouraged from filing charges and lawsuits and have won lawsuits as frequently, then the bill will not go into effect. When considering any legislation, this committee should first determine whether legislation is required, and next, whether the bill under consideration will improve the situation. The committee did not have a full hearing on H.R. 1230 and only heard from one witness invited by the Democrats about the bill. This legislation deserves a standalone hearing so that committee members can get more information to make a considered decision regarding this legislation. We want it to work. Publicly available data does not show that Supreme Court decisions in Gross or Nassar have discouraged individuals from filing EEOC charges. The Democrat-invited witness who testified at the May 21st hearing in favor of H.R. 1230 acknowledged that it is difficult to quantify the impact that Gross' decision has had on the number of older workers who bring cases and the number of those who win them. This witness also acknowledged that when we might have expected a drop in charges due to Gross-inspired discouragement from employment attorneys, there was a sizable jump in the number of ADEA charges filed with EEOC. A review of EEOC data shows that the rate of EEOC age discrimination charges as a percentage of all charges filed is approximately the same for the 9 years before and after the Gross decision. There has been a slight uptick in Title VII retaliation charges as a percentage of all charges filed in the 4 years following the Nassar decision, which does not indicate individuals have been discouraged from filing these charges. A review of court decisions shows that plaintiffs have continued to win age discrimination and Title VII retaliation cases in the wake of the Supreme Court's decisions in Gross and Nassar. This amendment will provide Congress much-needed data on the impact of the 2 Supreme Court cases at issue in H.R. 1230. If the GAO report indicates Gross and Nassar have not discouraged individuals from seeking relief or from achieving it, the bill does not need to go into effect. This committee should look before it leaps, and I urge my colleagues to vote in favor of this amendment. And, Mr. Chairman, I yield back.
Gentleman's time has expired. Gentleman from Michigan, Mr. Levin.
Thank you, Mr. Chairman. I appreciate
Gentleman's recognized for 5 minutes.
Oh, thank you. I appreciate my colleagues' intention in offering this amendment, but I speak against it. We don't need a GAO study at all to tell us that a substantially higher burden of proof for some forms of discrimination makes it far more difficult for workers who can prove discrimination to get their day in court, to survive summary judgment motions, and to prevail. When cases become materially more difficult to win, attorneys become much less willing to represent workers in these cases. We've already had a 10-year delay in restoring justice. No more delays are warranted. Unfortunately, age discrimination in the workplace is still disturbingly pervasive. According to an AARP survey released last year, 3 in 5 older workers report that they have seen or experienced themselves age discrimination on the job. Nearly 2/3 of women and more than 3/4 of African American workers age 45 and older say they've seen or experienced age discrimination in the workplace. 3/4 of workers age 45 and older blame age discrimination for their lack of confidence in finding a new job. 3/4. And Mr. Chairman, I don't really need any studies to know about this because I ran the workforce system of the state of Michigan for 4 years, and over again, I ran into workers who had lost their jobs because of age discrimination, and they weren't even contemplating taking legal action. They were just coming to us seeking help to find a new job. I remember a gentleman from Bay City, Michigan, who had been in college when his dad died of a heart attack suddenly. And his mom said, "Sorry, son, everybody's got to go help keep the family afloat." And he went to work in retail, and now, 30 years later, he had been a manager at a sporting goods store. And the corporation looked at him one day and said, "Gee, we could get somebody way younger to run this store for half the money," and they just got rid of him. And here he was. He came back. Thankfully, we had the No Worker Left Behind program, and he was able to go back and finish his bachelor's degree. I ran into those cases over and over, Mr. Chairman. The enactment of the ADEA in 1967, amidst the enactment of the Equal Pay Act, the Civil Rights Act, the Voting Rights Act, and the Fair Housing Act, was an important and integral part of congressional actions to define and protect civil rights in the 1960s. But over the years, the courts have failed to interpret the ADEA as a civil rights statute like the others, and instead has narrowly interpreted its protections and broadly construed its exceptions, compounding the barriers facing older workers. The Protecting Older Workers Against Discrimination Act is a bipartisan proposal that reinstates the legal standard for proving age discrimination with the standard for proving discrimination based on sex, race, or national origin. It's that simple. This amendment is simply intended to delay indefinitely implementation of bipartisan legislation. There is no deadline for the GAO to conduct the study and report back to Congress, And in fact, it calls for not moving forward depending on the outcome of the study when we know we need to move forward right now. This amendment will not protect workers from discrimination, and I urge my colleagues to join me in opposing it. Thank you very much, and I yield back.
Thank you. Are there other comments on the amendment? If not, gentlelady from Oregon.
Mr. Chairman, I withdraw the point of order.
Point of order is withdrawn. The question is now on the amendment. All in favor of the amendment will say aye.
Aye.
All opposed, say no. No. Noes appear to have it. Recorded vote is requested, and that will be pursuant to the rules, roll to the end. Are there other amendments?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment offered by Ms. Fox to the amendment in the nature of a substitute to H.R. 1230.
Mr. Chairman,
Gentlelady from Oregon.
I reserve a point of order.
Point of order is reserved and will delay for a second as the amendment is distributed. Gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. Taking a negative employment action against an employee because that employee has previously made a discrimination complaint is wrong, and it is already illegal. However, H.R. 1230 reduces the standard of proof by allowing mixed motive claims in retaliation cases, overturning the Supreme Court's 2013 decision in the Nassar case. This provision in the bill is particularly ill-advised. Justice Anthony Kennedy wrote in the majority opinion in Nassar that in retaliation cases, quote, lessening the causation standard could also contribute to the filing of frivolous claims, which would siphon resources from efforts by employers, administrative agencies, and courts to combat workplace harassment, end quote. Justice Kennedy also wrote in his Nassar opinion that the concern about diverting resources was especially true because retaliation charges filed at the EEOC had nearly doubled in the past 15 years and had become the second most frequently filed category of charge. This concern is even more relevant today because retaliation is now the most frequently filed EEOC charge. Allowing mixed motive claims in retaliation cases is unworkable and contrary to the text, structure, and history of Title VII. All retaliation claims are inherently about differing explanations. The plaintiff has already made a discrimination complaint, and under the mixed motive standard, it will be a mere formality to plead the subsequent employment action in question was retaliatory. Under H.R. 1230, a plaintiff will always survive the summary judgment stage of the litigation, and the case will either settle or go to trial, increasing the financial cost noted in the Supreme Court decision and reducing important resources that could otherwise be used to combat discrimination. It may surprise the large majority of these plaintiffs to learn that in nearly all mixed motive cases under H.R. 1230, they will be awarded no monetary damages and will not be entitled to reinstatement. The only ones to be paid in the vast majority of these cases will be the plaintiff's lawyers. There's no evidence employees have been harmed by the Nassar decision. They have not been discouraged from filing retaliation charges with the EOC, and they still win lawsuits claiming retaliation. And by the way, when employees win lawsuits claiming retaliation under the current standard, they can receive monetary damages, back pay, and reinstatement, as well as attorney's fees and costs. Under H.R. 1230, nearly all successful plaintiffs will not receive any monetary damages, pay, or reinstatement. Only the trial lawyers get paid. This amendment strikes the unworkable and ill-advised provision in H.R. 1230 allowing mixed motive claims in Title VII retaliation cases, which will keep in place the current standard of proof as described in the Nassar case, and committee members are urged to support it.
Gentlelady's time has expired. Someone wish to get recognized in opposition to the amendment? Gentlelady from Illinois, Ms. Underwood.
Thank you, Mr. Chairman. Enforcement of civil rights laws relies heavily on individuals to assert their rights. The willingness and ability of workers to assert their rights by filing charges are severely undermined if they are not protected from retaliation for doing so. Thus, every civil rights law makes it a separate act of discrimination for an employer to retaliate against employees for exercising their civil rights or opposing unlawful acts. In this way, employers are more likely to be deterred from bad acts, thus resulting in fewer cases being filed. The fact that charges of retaliation are the most commonly filed type of charge with the EEOC supports retention of strong protections against intimidation and retaliation. If a worker can be more easily fired or otherwise penalized for challenging discrimination, this strips away the underlying protections of the law, whether under Title VII or under any of the other civil rights laws. The but-for causation requirement is a legal barrier to proving age discrimination. Even before Nassar, where the Supreme Court imposed the but-for causation in the Title VII anti-retaliation provision, it was clear that lower courts were already applying gross to that provision. There have been 10 years of precedent and continuing damage. Amending one law but leaving out others heightens the risk that courts will interpret Nassar as correctly decided and possibly apply it to retaliation cases arising under other laws. I urge a no vote. And yield back.
Thank you. Gentlelady's time has expired. Are there other gentlemen from Alabama? Mr. Burr.
Thank you, Mr. Chairman. Presently under Title VII.
5 minutes.
Presently under Title VII, retaliation is prohibited, and if a plaintiff can prove their case, the plaintiff can receive monetary damages. That's a pretty strong motive for an employer not to retaliate, and that's the intent of the law, and that's the way the law is applied in the courts. What we're talking about today is not changing that, but changing whether you have to have the but-for standard or the mixed motive standard. And the effect of that is if you allow the mixed motive standard, there are no damages. So if we're really here today to try to look out for the employees, then we should not be for allowing the mixed motive standard in a retaliation case, because that removes the possibility for damages, which not only pays the employee, but it's a very strong motivating factor for the employer not to retaliate. So this amendment helps employees who may have a retaliation claim. It doesn't hurt them. I think the underlying bill actually hurts them. So I'm in strong support of the amendment for that reason. I yield back.
Gentleman's time has expired. Do others wish to speak to the amendment? Gentlelady from Oregon.
Mr. Chairman, I withdraw my point of order.
Gentlelady withdraws her point of order. Question now is on the amendment. All in favor of the amendment will say aye.
Aye.
All opposed, say no. No. The opinion of the chair, the noes have it.
Mr. Chairman, I ask for a recorded vote.
Recorded vote is requested and will be rolled to the end. Are there other amendments? There being no other amendments, the question now occurs on the amendment in nature of a substitute as amended, and that can't take place now until we've dispensed with the amendments at the end. So we'll roll the votes at this point till the end. Question now occurs on, the committee now will proceed with the consideration of the bill H.R. 1309 for amendment. The bill was circulated in advance and printed copies are available. Without objection, the first reading of the bill is dispensed with. Without objection, the bill will be considered as read and open for amendment at any point. Any amendment offered shall be considered as read. With the, I now recognize the gentleman from Connecticut for the purpose of an amendment in nature of a substitute.
Thank you, Mr. Chairman. Mr. Chairman, I wish to offer an amendment in the nature of a substitute.
Clerk will designate the amendment.
Amendment in the nature of a substitute to H.R. 1309, offered by Mr. Courtney of Connecticut.
The amendment in nature of a substitute has already been distributed, and I now recognize the gentleman from Connecticut for 5 minutes to describe his amendment in nature of a substitute.
Thank you, Chairman Scott, for convening today's markup on this legislation, and to Chairwoman Adams for taking urgent action on this issue in the Workforce Protection Subcommittee early in the 116th Congress. Mr. Chairman, this is a momentous step in a years-long process to address the serious problem of violence against the caregivers, medical professionals, and social workers who are enduring frightening rates of violent attacks while they are healing, caring for, and consoling patients all across America. Every person who has worked in a hospital, a psychiatric aide, a social worker, emergency responders knows how serious and pervasive this problem is and how it affects their ability to do their jobs. The primary source of this violence comes in the form of assaults: kicking, hitting, spitting, verbal threats from patients, residents, and clients, or those who accompany them. It affects workers' sense of safety at work, contributes to burnout, high workers' compensation costs, stress, and traumatizes the patients and other staff who witness these events. As the CEO of the Cleveland Clinic, one of the largest healthcare systems in our country, Tom Mihailovic said recently at his 2019 State of the Clinic address, workplace violence is an epidemic for healthcare workers, and called it a fundamental problem in U.S. healthcare that very few people speak about. In 2018, the Cleveland Clinic confiscated an incredible 30,000 weapons from patients and visitors in Northeast Ohio. And that's obviously not a problem that's just limited to that region of the country. It is all across the country. Closer to home in the state of Connecticut, an incident that occurred to Helene Andrews, a registered nurse from Congresswoman Johanna Hayes' district in Danbury, was assaulted multiple times during her career. Shortly before she retired, she was thrown to the floor by a patient and her pelvis was shattered. In 2013, this committee started oversight of this problem and requested a report from the Government Accountability Office to determine how pervasive this violence is and what strategies at our disposal to reverse the trend. The report, which was completed in 2016, found that workers in healthcare facilities experience substantially higher rates of non-fatal injury due to violence in the workplace compared to workers overall. The graph that's on the screen shows how appalling this disparity is. These events should not be part of the job. They should not be a daily, weekly, or monthly occurrence, but unfortunately the data shows us otherwise. Between 2006 and 2017, there was a 70% increase in violent incidents that occurred in healthcare and social service workplaces that resulted in employees being away from work. According to the Bureau of Labor Statistics, healthcare and social service workers are nearly 5 times more likely to suffer a serious injury from a workplace violence than workers in other settings. Up to 30% of hospital workers report being assaulted at work. For employees in psychiatric hospitals, that number is drastically higher. Nearly 50% of emergency room physicians have been physically assaulted at work, and 80% report that this violence affects patient care. Despite these alarming statistics, we know that violence against this workforce is grossly underreported. Many medical professionals are discouraged from reporting incidents at all. Fear further stigmatizing patients, or just think that it's part of the job. Just shake it off, keep moving. It's not going to result in anything, so don't report it. We also know that these incidents are preventable. Since 1996, OSHA has published voluntary guidelines that recommend common sense preventative measures that employers can take to reduce the risk and severity of violent incidents. While these guidelines are an excellent resource, the fact that we continue to see a growth in violence means that voluntary actions alone are not enough. In order to ensure that OSHA guidelines are adopted and implemented, we need to provide OSHA with an enforceable standard. That's why in 2016, after receiving the GAO report, 5 members of the House and Senate asked OSHA to begin rulemaking on a standard to protect healthcare and social service workers from violence. In 2017, in January 2017, President Obama's OSHA announced that they would initiate a rulemaking process, a move that signaled to millions of healthcare employees that government would be on their side to helping to provide a safer workplace. However, Since then, OSHA has sputtered and stalled. Later in 2017, under the new administration, OSHA removed the issue from its active regulatory agenda. Then in 2018, it placed it back on. However, they have twice delayed even the smallest first baby step in terms of rulemaking, convening a panel of affected small businesses. It is clear that this administration is not making this a priority. As Secretary Acosta testified before our committee, this bill before us will. Very simply, the standard required by the legislation would require that covered employers such as hospitals and psychiatric treatment facilities develop a workplace violence prevention plan that is tailored to the specific conditions and hazards present at each workplace. I'd like to emphasize that this standard is far from a one-size-fits-all standard, and instead, in Section 103 of the bill, it explicitly requires that the violence prevention plans be, quote, tailored to the specific conditions and hazards for each facility. Each employer would be responsible for assessing and identifying the risks that their employees face and take measures to mitigate those risks. These include work practice controls, such as sharing information with caregivers on a patient or client's history of violence, training on de-escalation techniques, and ensuring workers are not isolated when dealing with a high-risk patient. Other measures could, but must include engineering controls such as weapon detectors, securing furniture, improving lighting, and sufficient security alarms. Many of these interventions, by the way, are already recommended and outlined by the Joint Commission, a body that accredits hospitals. While we will never eliminate all risk or stop every violent attack, research on the measures in this legislation, which have been implemented in some states, have been shown to substantially mitigate risk of serious injury from workplace violence. The amendment in the nature of the substitute will make two main changes to the base bill, H.R. 1309. Number one, when there are multiple employers operating in a facility, it requires procedures for determining which employer or employers are responsible for implementing and complying with the provisions of the standard. This change was made at the request of healthcare employer groups to keep the chain of command in a multi-employer setting clear and distinct. Secondly, flexibility is provided in the provision of annual training. After initial in-person training, employers can use live video conference in cases where in-person training is not practicable. This change acknowledges that many employees covered by this bill, especially social service workers, do not routinely visit one centralized workplace. Once again, this change was made at the request of healthcare and social service employers who are seeking to improve this bill that will protect their workers. I'd like to thank the many researchers, professionals, and medical societies, union representatives, and individual workers who contributed to this legislation. I want to thank particularly John Brady, an RN from Connecticut who has worked tirelessly on this issue and who is here today. This bill is certainly better, and thank you to all of your input and support. I urge a yes vote on the amendment in the nature of a substitute, and I yield back.
Thank you. Are there members who wish to speak on the amendment? Gentlelady from North Carolina.
This gentlelady from North Carolina.
I'm sorry.
Thank you, Mr. Chairman.
Gentlelady is recognized for 5 minutes.
It pains me to speak in opposition to this amendment in the nature of a substitute and, by extension, the bill itself, because at the heart of this issue there is much agreement. Republicans and Democrats agree that health care and social service workers face real and unique risks of workforce violence. Not only do we agree, but OSHA agrees. That's why OSHA has begun the necessary work to produce a thoughtful, forward-looking policy through its rulemaking authority to protect healthcare workers and those they serve. What OSHA is doing is a necessary step. We know workplace violence in the healthcare and sector services is on the rise. According to the Bureau of Labor Statistics in 2017, these were the workers who suffered more than 70% of all workplace violence injuries that were caused by individuals. If OSHA were ignoring its responsibilities to protect healthcare workers, that'd be a different matter entirely. But we are aware that OSHA has already scheduled a Small Business Regulatory Enforcement Fairness Act panel, an important part of the rulemaking process that considers potential impact on small businesses by including their valuable feedback on possible solutions. This process in no way conflicts with OSHA's ability to enforce workplace violence protections in this sector under the General Duty Clause. And incidentally, even my colleague from Connecticut mentioned that the Obama administration took absolutely no action on this for 8 complete years, and not until the time it's about to go out of office did it raise the issue. So the Trump administration's moving more expeditiously on it. It should not go without mentioning that, again, that it happened after delays of 8 years on the Obama administration. Healthcare and social service workers do need a workable solution, and the agency whose purpose it is to deliver that solution is finally doing its job. It's doing its job the way we want federal agencies to do this work, by seeking and including the input of those who know better than we do how to prevent future incidents. Healthcare workers are familiar with the Hippocratic Oath, first, do no harm. In its rush to judgment, H.R. 1309 does great harm. By short-circuiting the public input process and prescribing a specific end result from the beginning, this bill will not achieve what it purports to accomplish. This bill is essentially telling the Department of Labor that we have no expectation of transparency or accountability to the American people, and that could not be further from the truth. We can do better, and we have come prepared to offer a better solution. We'll do so momentarily, but for now, I yield back.
Gentlelady's time has expired. The other gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady.
Thank you, Mr. Chairman. I am in strong support of H.R. 1309. During our hearing of February 27th, I listened to the testimony of Nurse Patty Moon Updike, where she described how she was attacked and seriously injured while just doing her job. I listened to her describe with tears in her eyes how she would never be able to work again in the profession she loved because of the post-traumatic stress disorder she still suffers from. And I listened to her discuss how, as a public employee, she would not be covered by any eventual OSHA standard if this bill does not pass. Mr. Chairman, passage of this bill is the least we can do to ensure the safety of our frontline healthcare workers, the people who work in our nation's hospitals and nursing homes and other healthcare institutions, as well as social workers and other health providers, offer critical assistance to those in need. They fulfill this role despite inadequate pay, odd and difficult hours, and the frequent threat of violence at the hands of people they serve. Today, the committee will stand up for these tireless laborers. H.R. 1309, the Workplace Violence Prevention for Healthcare and Social Workers Act, would require OSHA to issue a strong violence prevention standard. It would compel OSHA to issue a standard requiring employers within the healthcare and social service sectors to develop and implement a workplace violence prevention plan. That plan would identify risks, specifically both work practices and environmental controls, require training, reporting, and incident investigations. The standard would require employers to maintain a violence incident log and prepare an annual summary of such incidents. It would also extend protections to public employees in the 24 states not covered by OSHA protections by requiring state healthcare institutions and social service agencies that receive Medicare funds to comply with the standard. And finally, instead of forcing healthcare and social service workers to wait years or decades for effective OSHA protections, this legislation would require OSHA to issue an interim final standard 1 year after enactment and a final standard within 42 months of enactment. These are not radical, impractical, infeasible, or unaffordable requirements. And while the federal government's efforts have stalled, some states have already adopted violence prevention standards that protect healthcare workers without putting an undue burden on employers. The measures that H.R. 1309 would require OSHA to include in the standard are almost exactly the same as what OSHA has been recommending in its guidance documents. They are also nearly identical to the Joint Commission recommendations for healthcare institutions across the country. The difference is that these measures would, for the first time, be enforceable. Healthcare and social service workers do important life-saving work, and the least we can do is ensure that they come home safe at the end of their workday. I urge the committee to pass this common sense, life-saving legislation, and Mr. Chair, I yield back balance of my time.
Thank you. Gentlelady's time has expired. Gentleman from Tennessee, Dr. Rowe.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman's recognized for 5 minutes.
I think probably I'm the only one in here that's actually, maybe someone else has, but spent time in emergency rooms. And I got pretty good at ducking drunk swinging at me, and certainly it's, and all the many times I've worked in ERs, I have always worried about it for the nurses, the lab technicians, myself, who are down there. And I would like to support this, and I'd like to have admitted to the record the American Hospital Association's letter.
Without objection.
Thank you. Let me just read from it a little bit. And obviously, it's a huge organization, represents lots of people. And just to read their comment, I wondered how they felt about it. It says, America's hospitals and healthcare systems are committed to a culture of safety for every worker, patient, and family member who enters our facility. However, because hospitals have already implemented specifically tailored policies and programs to address workplace violence, we do not believe that the OSHA standard required by H.R. 1309 are warranted, nor do we support an expedited approach that would deny the public the opportunity to review and comment on proposed regulations. So I think they want to do that. I mean, no one is more interested in having a safe workplace than the hospitals that see patients. Obviously, we have to recruit nurses and other healthcare providers and doctors, and we want it to be safe. And so my question is, this has been going on forever. What's the hurry? Why don't we do this, Mr. Chairman, in a bipartisan way and get to a point where we can all agree on this, have the American Hospital Association in to testify and see what their issues are? I didn't know this until I just picked this up a couple of minutes ago. So that's what I would recommend. I think you could find a great bipartisan agreement if we would do just that. With that, I yield back.
Gentleman yields back. The gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I move to strike the last word.
Ladies recognized for 5 minutes.
Thank you, Mr. Chairman. In Portland, Oregon, at an organization called Outside In, Oregon AFSCME members are doing important work by providing essential support services to youth who are struggling with substance use disorders, homelessness, and behavioral health issues. A few years ago, 2 workers were tragically wounded in a work site stabbing. I remember the day quite well because at the time my son was teaching at Outside In. Needless to say, I was relieved to get an email that he was off campus, but I was, of course, very concerned about his coworkers. It was after that incident that workers organized to improve difficult working conditions that were compromising the quality of services for the vulnerable clients they serve. Unfortunately, the experience of these workers was not unique. According to a November 2018 report from the U.S. Bureau of Labor Statistics, healthcare and social service workers face a disproportionate risk of on-the-job violence and injuries. The Occupational Safety and Health Administration does not require employers to implement workplace violence prevention programs, perpetuating the unacceptably high risk of injury for many workers. The workers at Outside In and healthcare and social service workers across the country need an evidence-based workplace violence prevention plan that's tailored to the needs of the populations they serve. Fortunately, several states, including my home state of Oregon, have taken steps to better protect healthcare workers. In fact, just last week, the Oregon State Legislature passed a bill to require healthcare employers to conduct a comprehensive safety evaluation using a state or nationally recognized workplace violence prevention toolkit. In our state, this will also require employers to document when, where, and how assaults occur with the goal of developing new systems to prevent similar instances in the future. These are important steps, but comprehensive and enforceable standards must be established at the federal level. I'm proud to be an original co-sponsor of Congressman Courtney's Workplace Violence Prevention for Healthcare and Social Service Workers Act. The bill would direct OSHA to issue a workplace violation prevention standard that requires healthcare and social service employers to develop and implement a plan to protect their employees from workplace violence. Healthcare and social service workers help to care for our family, friends, loved ones, and neighbors. Together, today, we can have a chance to support their well-being by helping them be safe in the workplace. And Mr. Chairman, I request unanimous consent to enter into the record a letter from Oregon AFSCME Council 75 in support of this bill.
Without objection.
I urge my colleagues to support this amendment in the nature of a substitute in the underlying bill, and I yield back the balance of my time.
Gentlelady's time has expired. Do the others wish to speak? Gentleman from Michigan.
Thank you, Mr. Chairman. Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and we appreciate the purpose of this legislation. Concerned about some of the process, of course. Responding to my good friend and colleague from Tennessee, I've spent a lot of time in emergency rooms as a patient, but also I remember a time in my life when I was on a hospital police force, and it was called STAT numerous times to restrain abusive, violent patients from causing risk to themselves as well as risk to the wonderful staff, nurses, doctors, technicians that were working on them as well. So we see the problem. We want to make sure that we continue to do the right thing. Republicans and Democrats, I believe, fully agree that healthcare and social service workers face real risks of workplace violence, and OSHA has recognized this challenge to healthcare workplace. The Bureau of Labor Statistics reports the healthcare and social service industries experience the highest rates of injuries caused by workplace violence. In 2017, BLS reported that healthcare and social service workers suffered 71% of all workplace violence injuries caused by persons. Workplace violence in healthcare and social service sectors is increasing. The Bureau of Labor Statistics data show that private sector injury rates of workplace violence in healthcare and social service sectors increased by 63% between 2006 and 2016. OSHA has taken steps to analyze the issue and determine what type of policy would be best, both to protect these workers and to provide employees and employers with the necessary flexibility to ensure employees are safe on the job. The agency is in the process of beginning a Small Business Regulatory Enforcement and Fairness Act panel. This part of the rulemaking process allows the agency to gather feedback from small businesses before issuing a notice of proposed rulemaking. In the meantime, OSHA is currently enforcing workplace violence under the General Duty Clause, Section 5A1 of the OSHA Act, therefore allowing the agency the ability to complete the rulemaking process is not leaving a key sector without enforcement. OSHA issued citations to healthcare facilities under the General Duty Clause related to workplace violence incidents in 2017 and 2018. H.R. 1309, though I believe takes the wrong approach, prejudging and imposing a solution without allowing important stakeholder input, which will result in a flawed regulatory approach which will potentially harm employers and employees. H.R. 1309 forces OSHA to omit important statutory steps in the rulemaking process, including the Small Business Regulatory Enforcement Fairness Act, SBREFA, and its panel. The federal rulemaking process was created to give the public and all impacted stakeholders an opportunity to provide their various expertise and experience on issues prior to it being enforced. This bill eliminates important steps in the rulemaking process and jumps straight to the enforceable standard. Under H.R. 1309, if OSHA found through research and public comment specific provisions in the legislation are wrong and wrong approach, its research identified a more effective solution, the agency would still be required to follow the overly prescriptive provisions specified in H.R. 1309. H.R. 1309 prevents the regular rulemaking process from proceeding by requiring an interim final standard, and final standard meet arbitrary timelines and specifications. This will ultimately hurt the very people it's intended to protect. H.R. 1309 requires OSHA to begin enforcement of a workplace violence prevention standard on the healthcare and social service industries within a year without giving the public and impacted stakeholders the ability to provide meaningful comment. We agree that OSHA should promulgate a workplace violence prevention standard for healthcare and social service industries, but H.R. 1309 is the wrong solution. I would encourage us to consider that and to think more wisely about what we're doing before we do it. I thank you, and I yield back.
Thank you. Gentleman's time has expired. Gentlelady from Minnesota, Mr. Ipaul.
Washington?
Washington, excuse me.
I like Minnesota. Thank you, Mr. Chairman. Mr. Chairman, every day, mental health workers and social service providers go to work in group homes, clinics, hospitals, treatment facilities, and individual homes. These admirable workers chose to dedicate their lives to providing encouragement, healing, and support to those that they work with. But right now, these same workers face the threat of violence every day on the job. And what's more, that violence is actually predictable and preventable. Employers need a clear and enforceable standard that they must be held accountable to, or the violence will get worse. Mr. Chairman, I ask unanimous consent to introduce to the record a letter from my state AFSCME Council 28 chapter.
Without objection.
Thank you. In the letter, they talk about one of my state's residents, a woman named Krista Butters, a licensed practical nurse at a Washington State psychiatric hospital. While Ms. Butters was at work, a patient punched her from behind, knocked her down, and then stomped on her head, threatening to kill her. As a result of this horrific violence, Ms. Butters can't work, she has continuing medical needs, and is receiving weekly sessions with a speech therapist and mental health support for the trauma she experienced. This terrible assault was predictable, and it was preventable. Hospital management could have made different choices about where that patient was placed in the facility in response to a level of risk that management was already aware of. Management could also have made different choices about staffing to ensure that there were more staff able to provide de-escalation support sooner. Management should have had a plan to predict and plan for potential violence like this. It's not the fault of hardworking mental health and social service providers that this preventable violence occurs, nor is it the fault of their patients and clients who are receiving services from these professionals in the first place because they're in crisis. Instead, it is management's ability and responsibility to prevent this violence. This interim rule is so important because healthcare and social service workers are facing dangerous workplace violence right now, and it's getting worse. Assaults are an epidemic. In 2016, the GAO completed an exhaustive and thorough report that found workplace violence to be a serious concern for the approximately 15 million healthcare workers in the United States. Healthcare workers are twice as likely to suffer a workplace violence injury as other occupations, and workers in psychiatric settings are at especially great risk, with a workplace violence injury rate of 181.1 per 10,000 workers, the highest ever recorded for this industry. And the injuries the workers face are severe, causing those workers long-term mental and physical harm. Just last month, in May, a staff member at a forensic treatment ward in Washington State had her thumb bitten off completely while she was performing her duties. We need a clear interim final standard now, while OSHA does the longer-term work of preparing and issuing a workplace violence prevention standard. The truth is, OSHA can and has issued a similar interim standard before. In 1986, as part of the Superfund Amendments and Reauthorization Act, Congress mandated the issuance of an interim standard for hazardous waste operations and emergency response within 60 days, and a final standard within 1 year of that act's enactment. In 1992, Congress mandated OSHA to issue the lead in construction standard. OSHA was required to issue an interim final regulation for lead within 180 days, and the standard was then issued in 1993. The interim standard will be flexible enough to be tailored to the needs of each workplace where it was required. The basic elements the interim standard would require: a workplace violence plan, training, record keeping, incident investigation, and anti-retaliation language are commonly accepted elements of all successful workplace violence programs that have been proven to be effective. Within those basic elements, employers will have the latitude to create their own programs appropriate to the size, complexity, and types of operation at their specific facility or for their specific service. The standard will be based on voluntary OSHA guidelines that have existed since 1996, guidelines that were updated in 2015. The interim final standard is legal. It is based on clear and obvious workplace safety principles and urgently necessary. I urge my colleagues to vote for this bill, and I thank the chairman and the sponsor of the bill for offering. Thank you, Mr. Chairman. I yield back.
I thank the gentlelady from Washington for her comments. Gentleman from Wisconsin, Mr. Grothman.
Just a quick comment. It'd be nice if this bill would prevent workplace violence. I will tell you this, whenever I talk to anybody in the healthcare field, mental health facility, nursing home, emergency room, a big complaint is too much paperwork. And I sometimes wonder, given the blizzard of paperwork we have today's world compared to, say, 40 years ago, whether it's improved anything. In any event, this bill, I'm sure it's well-meaning, just to me smacks of a lot more paperwork. I hope we get some out of it, but I yield.
Gentleman's time has expired. Gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you. My district, the 7th District of Pennsylvania, has the luxury of having large health networks that are held in high esteem. And those health networks are respected because of the employees that staff them. Dr. Rowe, I am not a healthcare worker nor a physician, but I have represented them for more than 25 years. 75% of my practice was devoted to the representation of hospitals and healthcare workers, including physicians, and I've heard all of their stories. The triage nurse working the 3rd shift at St. Luke's Hospital, the physician extender with the trained eye to identify domestic or substance abuse at Good Shepherd Hospital, the trauma surgeon with the skilled hands to complete even the most difficult of surgeries at Lehigh Valley Hospital, the emergency room physicians and nurses dealing with drug addiction and patients in the throes of alcohol detox. They all come from different backgrounds, but they all share the same goal of positive patient outcome. Their attention is properly devoted to the vital signs of the patient on the ventilator or the glucose level of the patient with diabetic ketoacidosis, or forming their differential diagnoses, or turning their patients to make sure they don't develop bed sores. Enough weighs on medical professionals' minds during a shift that they should not be distracted by the fear of workplace violence. But the sad reality is that workplace violence is prevalent in the healthcare industry. Studies have found that 19 to 30% of hospital workers have been assaulted at work. And as that problem worsens, including a 158% increase in incidents from 2008 to 2017, we are also seeing a shortage of registered nurses and physicians, a shortage that is only expected to worsen as the baby boomer generation ages. I am a proud co-sponsor of the Workplace Violence Prevention for Healthcare and Social Service Workers Act, requiring employers to develop minimum violence prevention plans, train employees on an annual basis, and report and track violent incidents will reduce workplace violence. Hospitals that have enacted similar measures saw a reduction in violence-related injuries by 55% over 3 years. This bill is the least we can do to protect those who care for all of us. Please vote yes on this important piece of legislation. I yield back, Mr. Chairman.
Gentlelady's time has expired. The gentleman from Michigan, Mr. Levin.
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I'm proud to be an original co-sponsor of the Workplace Violence Prevention for Healthcare and Social Service Workers Act, and I'm proud to speak up today in support of the amendment in the nature of a substitute. It should not be a condition of work or employment to be beaten, abused, assaulted, and threatened, especially for some of this country's most vital and admirable workers who take care of us when we're sick or in distress. We cannot wait for OSHA to set a standard through its regular procedures and let years or decades go by while hardworking, essential healthcare and social service workers go to work every day to face the very real threat of abuse. I first learned about this issue when I started helping nursing home workers organize with SEIU in the 1980s. And I would house visit workers every day and hear their stories of abuse they would face from patients, intentional or otherwise. And again in the 90s and early 2000s when I helped healthcare workers from many unions organize when I was at the AFL-CIO. It's really a silent epidemic out there, and we need to act on it and act now. And I want to point out, Mr. Chairman, that, you know, when we move forward with important legislation here, we're not working on our own. We're working in partnership with organizations out there who bring the evidence to us and prod us to act. And today, I want to recognize National Nurses United and its president, Gene Ross, who are in the House here in the hearing today, who've led the fight for workplace violence prevention for years. And the NNU has achieved landmark legislation in California, in fact. So I thank the NNU for showing that workplace violence prevention is so important, but also that it not only protects nurses and other healthcare workers, but also protects patients as well. The measures that this bill requires are simple and evidence-based and will protect hardworking Americans whose care is so necessary. I want to thank, in particular, Representative Joe Courtney for leading this effort, and you, Mr. Chairman, for your work on this bill, and I strongly encourage my colleagues to support it. Thank you, and I yield back.
Thank you. Gentleman's time has expired. Do other members wish to speak? Gentlelady from Florida, Ms. Shalala.
Thank you, Mr. Chairman. I move to strike the last word.
Ladies recognized for 5 minutes.
And I ask unanimous consent to submit for the record a letter from Martha Baker from my state of Florida representing SEIU and over 1 million healthcare and social service workers, and a letter from Randy Weingarten, the president of the American Federation of Teachers, which also represents thousands of people who work in the healthcare system.
Without objection.
Mr. Chairman, I would just like to make 2 points. One is it is not unusual for the federal government, on recognizing there is uneven coverage between states to protect workers, to ask OSHA to set a standard for all of those workers. This bill provides plenty of a time for comment, including Representative Stevens' amendment that adds a 30-day comment period to the interim final standard, as well as continuing to require OSHA under the law to go through a full rulemaking process, including a hearing and extensive public comment. For those hospitals that have already implemented effective programs to address workplace violence, they should not have more work to do. Much more work to do. The interim and final standards will be program standards, which means that the elements required by H.R. 1309 will only determine the basic elements of a workplace violence program. That is the appropriate role for the federal government. We've done it in a whole bunch of other standards, including the privacy regulations, which were implemented in the 1990s. A worker should not have to be concerned no matter which hospital they work in this country, and it's important that workplace safety standards are similar and protect workers no matter where they work in the healthcare system. Thank you. I yield back.
Thank you. The gentlelady's time has expired. Do others wish to speak on it? If not, I now recognize myself for 5 minutes to strike the last word, just to point out that these plans work. They significantly reduce violence at the workplace. And I think the other points that I have in my statement have already been made, so I'll introduce the statement for the record. The other comments on the motion on the amendment nature of a substitute? If not, we will now proceed to amendments. There is one amendment offered on the roster from the gentlelady from Michigan, Ms. Stevens. Ms. Stevens, would you like to offer the amendment?
Yes.
Gentlelady is recognized for the purpose of offering an amendment.
Thank you, Mr. Chairman. I have an amendment at the desk. This amendment.
Clerk will report the amendment.
Thank you.
Amendment to the amendment in the nature of a substitute to H.R. 1309, offered by Ms. Stevens of Michigan.
Gentlelady is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. I have an amendment at the desk. This amendment requires OSHA.
Wait a minute, has the amendment been passed out? Amendment's being passed out. It's in your, the amendment's in your folders. Gentlelady from Michigan.
This amendment requires OSHA to provide a 30-day notice and comment period before issuing an interim final standard as described in Section 101. We know that the final standard will have to go through the full rulemaking process, which includes different opportunities for public input. However, I believe this amendment is necessary to offer the public the opportunity to review and comment on proposed regulations at the onset. This amendment also responds to the concerns that have been raised today and in hearing from our friends on the other side of the aisle. And we can agree with certain parts of that perspective. Specifically, this amendment addresses the claim that we don't provide the opportunity for the public to input during the development of the interim of the final standard, that democracy is deliberative, it's discourse, and as rules and laws come into place, it is important to bring in the public voice. But this legislation is critical, it is important, and we will continue to bring in those voices to do what is right in looking to mitigate and respond to harm before it is conducted, and looking to protect and defend. The input from stakeholders is a vital part of the rulemaking process. And although the bill calls for OSHA to conduct its rulemaking process before the final standard is enforceable, and although OSHA has already conducted extensive outreach about workplace violence, this amendment ensures that public voices are heard at the beginning of the process so that there is greater input in the formation of the rule, the measured implementation. This amendment will ensure that before OSHA enforces any new requirements of hospitals or social service employers, they have ample opportunity to provide input. And that is why I ask my colleagues on both sides of the aisle to join me in passing this amendment to this important legislation. Thank you, and I yield back the remainder of my time, Mr. Chairman.
Yields back. Are there other comments on the amendment? Gentleman from Alabama, Mr. Byrne.
Thank you, Mr. Chairman. I appreciate the gentlelady's offering this amendment. Obviously, she recognizes that there's a deep flaw in the underlying bill, that it doesn't require a comment period. Unfortunately, I don't think 30 days is enough, given the prescriptions of the bill itself, but also just given the general nature of this topic. This is going to be a pretty far-reaching and, I think, complex regulation. 30 days is not enough time for all the stakeholders, people on all sides of this issue, to give their comments so that this thing is promulgated in a way that's thoughtful and actually addresses the issue. That's why I appreciate the intent of what she's doing. 30 days is just not nearly enough time for that to take place. And I hope that the committee would take a bigger view of this. What we need to do is to have a more deliberative process. And with that, I yield back.
Gentleman yields back. Are there other comments on the amendment? If not, I'll recognize myself just briefly to say it's not just 30 days. The people have a one-year warning that time is coming up. So it's not like the 30 days pops out of the blue. And they'll have plenty of time to offer their amendments. And I yield back. Others want to comment? Gentleman from Connecticut.
Thank you, Mr. Chairman. Again, I want to speak in support of the Congresswoman's amendment. Again, at the hearing that Chairwoman Adams convened back in February, again, Mr. Rath, who was the Republican witness, repeatedly pointed out the fact that the language in the bill was silent in terms of whether or not there was going to be an opportunity to submit comment to OSHA during the interim final rule. Again, I don't think the lack of any language meant that it precluded comment, but nonetheless, I think the Congresswoman's amendment today is just aimed to clearly state that all stakeholders will have that opportunity. As we know, frankly, from the hearing that we held, where we had 4 witnesses in a full day, and also the submissions that are already flooding into the committee from different groups out there, the awareness is extremely high. The groundwork has been laid because of the guidelines that OSHA developed back in the 1990s. As Congresswoman Shalala correctly stated, the bill is actually very non-prescriptive. It basically states that there'll be just program standards. Section 103, which I referenced in my opening remarks, explicitly states that this rule needs to be flexible in recognizing that there is great diversity in terms of different healthcare settings that are out there. So again, I think we're balancing here in terms of trying to make sure that there is going to be some expeditious action here, given the critical, urgent nature of this problem, as well as obviously balancing it to make sure that people will have a fair opportunity to weigh in. I just want to, again, remind, in closing, the members of the committee, OSHA's track record in terms of developing rules in the past is hardly one to celebrate. I was talking to my colleague from Arizona here. Developing an OSHA standard for beryllium took 19 years to get through the process. This is poison that people were exposed to at workplaces, and it took 19 years for OSHA to act. Silica dust took 20 years. And so, at the end of the day, OSHA is an act of Congress that was signed into law, by the way, by Richard Nixon. And we have the ability to say that, we're not going to just sort of be spectators here. We are going to actually accelerate this process where there is so much material and content and knowledge and experience that is swirling around out there. But again, giving people a fair opportunity to weigh in. Among those groups that have weighed in already during this is frankly Dr. Rowe's former colleagues, the American College of Emergency Physicians, who again have written in strong support of this bill. They recognize that voluntary guidelines waiting for OSHA is just not acceptable in terms of what's happening out there. The Emergency Nurses Association, which the American Hospital Association referenced in their letter that they sent over at 5 o'clock last night, touting the fact that they were working with the Emergency Nurses Association on some voluntary guidelines, they've submitted a letter in support of this bill because they realize this problem is spinning out of control. And we heard that from one of the witnesses who testified here, talking about, and we all know this, that the heroin opioid crisis is driving a lot of the violence that EMTs are encountering when they're picking up overdose patients, when they're showing up in emergency rooms. And this is not like the old harmless drunk taking a swing at somebody. These incidents that are happening out there are increasing in terms of volume, and we know that because of what's happening out there with the epidemic in terms of addiction. And we also know that behavioral health in general is an issue that as a country we have to address. But in the meantime, we should not put the caregivers in the crossfire of having to take the hits and pay the price for the fact that we've got a lot more work to do as a nation. So again, I applaud the amendment that's being offered. It balances the bill, responds to the testimony of Mr. Rath, and again, I think improves this legislation that we should, again, I hope, come together and support at the end of the day. I yield back.
Comments on the amendment?
Mr. Chairman, I'd like to reclaim my time.
The gentlelady's time has been yielded back. Recognize the gentlelady from Oregon to claim time and yield to the gentlelady from Michigan.
Mr. Chairman, I move to strike the last word.
Gentlelady's recognized.
I yield my time to Ms. Stevens from Michigan.
Thank you.
Thank you, Mr. Chairman. I know we choose to deliberate in this committee through public statements to a large audience viewed on camera and the other side of the aisle is pretty starkly drawn. I have heard from my colleagues today repeatedly about the public comment period. Not once did any of you mention the timeline of the period. We are offering a very sound amendment, a 30-day continuation to open that up to the public. This is supposed to be a bipartisan amendment, and the fact that it is being rejected and rebuked is absurd. We are trying to pass good legislation to keep people safe. The public is waiting for us to act. I take the responsibility as a federal legislator very seriously, recognizing that when we pass laws through the House of Representatives, it is federal legislation. And the public has asked us to do this, and we ask you to take that into consideration about what we are actually getting done here around when we bring the public voices in and what a 30-day comment period really means. Thank you.
Would the gentlelady yield?
My time will be yielded. That's fine.
Gentlelady yields back. Has he been?
I yield my time.
Gentleman from Tennessee is recognized.
Thank you, Mr. Chairman. I yield my time to Mr. Wahlberg.
Gentleman from Michigan.
I thank the gentleman. I appreciate the passion from my good friend, colleague, and delegation member from Michigan. But I think several of us mentioned the timeline significantly. That's one of the biggest problems we have. We believe that public comment ought to be there. We believe that generally public comment makes things better. We want that. I think this is too short still. I appreciate your movement that direction, but I truly think it's too short. And yes, OSHA has made a lot of mistakes over time. They haven't gone far enough at times or quickly enough. But to think that we could do something this quickly and be better than anything that could be done by OSHA, I would say that's a challenge as well to believe. So I accept the premise that you're moving in a better direction, but 30 days. I think there ought to be more time. So I just want to make sure you understood that I agree with you that we're moving in a better direction. But no, we made several statements. We think this is too short, and it takes the public out of the mix. I yield back.
The gentleman's time has expired. Are there other comments on the amendment? If not, the question is on the amendment. All in favor, say aye. Aye. All opposed, say no.
No.
The ayes appear to have it. The ayes have it. Are there other amendments? Gentleman from Alabama. Gentleman has an amendment at the desk.
Mr. Chairman, I reserve a point of order.
The lady from Oregon reserves this point of order. Clerk will designate the amendment.
Substitute for the amendment in the nature of a substitute to H.R. 1309, offered by Mr. Byrne.
The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the gentleman from Connecticut for raising this issue. Unlike the previous bill, which was a solution looking for a problem, there's a real problem here, and it needs to be addressed because our health care and our social service workers face real risks of workplace violence every day in their important work for our communities. And I do share the gentleman from Connecticut's frustration with OSHA. I don't know why the Obama administration waited 8 years to bring it to them, but we have got what we've got, and we need to move forward with it. Today, we can do right by them, working together to address the critical need for protection and the prevention of violence in the workplace. Impactful legislation is possible in an effective and bipartisan manner. But I echo the ranking member's observation that this bill is simply the wrong approach. While this stands no chance of becoming law as a purely partisan bill, I believe we have a real opportunity here to advance legislation that could be enacted and provide the protections for workers we all desire. As Dr. Fox said in her opening remarks, serious problems deserve serious answers. Rather than a rushed, overly prescriptive, and uninformed standard that ties the hands of agency experts, committee Republicans believe workers deserve a responsible, workable, and thorough solution to this serious issue. The amendment of the nature of the substitute that we are proposing today recognizes that OSHA, having noted the hazards and risks that exist with healthcare workers, is currently advancing the rulemaking process to address this important issue. This amendment would ensure that the regulated community has an opportunity to provide meaningful comments on a workplace violence prevention standard, which will inform an effective and workable final regulation before the agency begins enforcement. And it calls on OSHA to convene the already planned Small Business Regulatory Enforcement Fairness Act panel before proceeding with the rulemaking process to allow small businesses the opportunity to comment on regulatory text. Finally, the amendment would require OSHA to conduct an educational campaign on workplace violence prevention in healthcare and social service industries. This common sense amendment acknowledges and supports the work already underway and protects this progress so that it can further propel solutions to workplace violence. Addressing workplace violence prevention is crucial, but Republicans have been saying that and prioritizing solutions all along. The Obama administration delayed action on this issue and first made moves to initiate a rulemaking process in the final year of President Obama's 8-year tenure. Meanwhile, the Department of Labor is working on a workplace violence prevention rulemaking as we speak and has initiated the Small Business Regulatory Enforcement Act panel scheduled for October of this year. We agree that there is work to be done, but H.R. 1309 is not the answer. Addressing such a critical need with hasty promulgations to make up for lost time will cause more harm than good. Instead of setting a dangerous precedent by hurriedly slapping a bandage on an issue deserving of serious solutions, I hope we can better than that today as a committee and seriously consider the substitute proposal. Preventing workplace violence in healthcare and social service settings is crucial, and we should get this done together by allowing OSHA to develop a standard that results from the normal, proven rulemaking process, which brings all experts and parties to the table. I ask my colleagues to consider the substitute amendment so we can make real, meaningful steps toward protecting American workers in this industry. And I would renew my offer to the gentleman from Connecticut that I'm happy to go with him in any way you think appropriate to bring this matter to OSHA's attention and get them to move on this quicker. Because I'm afraid if we rely upon legislation, we're going to be here for a long time, and perhaps going together to them, we can tell them on a bipartisan basis that Congress recognizes this is a real problem, they need to get to work on it. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Connecticut is...
Thank you, Mr. Chairman.
Recognized for 5 minutes.
Thank you. Well, first of all, I just want to say to my friend, and I consider him a friend from Alabama, that, I've worked with you on many issues in other committees as well as this committee, and I have, just great respect for you, and I'm frustrated, frankly, that we're sort of parting ways here today on an issue which I truly believe you do understand is real. And your questioning at the hearing in February demonstrated that to me and to all the members of the committee. But, I think the problem with this amendment is that basically it's saying, we're just going to sit back and sort of let OSHA do its thing and sort of leave this issue in their hands. And I would just note that the new Secretary of Labor has been over to this committee twice. I have asked him each time about whether or not this is going to be a priority. After the first visit, they actually removed it from their action list. They did put it back on, and then they have scheduled multiple times now the hearing at the small business level, which is really a baby step in the OSHA process. As I said, their track record, GAO did a study, and they found that the average length of time going back years for OSHA to act is it's taken 7 years for them to issue a rule. And what our bill does is it says, upon enactment, you've got 42 months, which is a very healthy period of time for an issue which really has been studied quite extensively going back to the 1990s by OSHA when they issued their first voluntary guidelines, in which there is a ton of academic studies and recommendations and state actions which have shown real smart ways that we can make it less risky for people who, again, are doing God's work for every single one of us and every single one of our families that are out there. So again, this amendment eliminates the interim rule, which we just discussed a short time ago with Ms. Stevens' amendment. It eliminates the 42-month deadline. It basically strikes any sort of program standards that there has to be reporting for injuries that happen. Again, if somebody slips and falls in a healthcare facility, that incident has to be reported today. If there's a release of chemicals that takes place in a healthcare facility, that has to be reported today. But we're saying if a nurse gets punched out in the emergency room, or if many of the weapons that Cleveland Health Clinic is seizing from people, 30,000 in 2018, those are not considered serious enough to make part of a workplace safety violence prevention plan. I mean, I just think common sense screams out that we can do better than that for the caring professions in this country. The anti-retaliatory provisions that are in there for reporting, so that people will feel safe if they do get punched, that they're not going to get disciplined by reporting an incident like that, which unfortunately, the input that we've heard from a lot of the rank and file folks says is reality that's out there right now. That gets stricken from this amendment. I mean, it basically just says we're just gonna let this issue ride. It's ridden too long, and the trajectory is so scary in terms of again, the intensity of this problem in terms of what's happening out there. And we heard that over and over again at the hearing that we held, and certainly the input that we received from the GAO. So again, I'll stipulate that the prior administration should have acted faster on this. But I would just note that, it was this committee that in 2013 ordered the Government Accountability Office study. It came back in 2016, and shortly thereafter that the process was commenced. And it has been stop and start since then. That's not good enough. We know the facts. We know the reality of this issue. And unfortunately, this amendment really just kind of puts this issue in neutral. And the people who are out there working every day, they deserve better than that. And that's why I would respectfully recommend a no vote on this amendment and moving forward on the underlying bill. I yield back.
Would the gentleman yield? You mentioned the Cleveland Clinic has seized 30,000 weapons.
That was in the CEO's report a few months ago.
From the Cleveland Clinic?
Yes.
Oh, I'd like to see the source. Thank you very much.
Yeah, no, it was reported. I'd be happy to share that with you.
All right, thank you very much.
Gentleman's time has expired. Are there other comments? Gentlelady from North Carolina.
Thank you, Mr. Chairman. Move to strike the last word.
Gentlelady is recognized for 5 minutes. I'm sorry.
Thank you. H.R. 1309 requires the employer to send annual summaries of the frequency, quantity, and severity of the workplace violence, including incident response and post-incident investigation. And that makes sense. The information contained on the log is essential for OSHA to be able to efficiently target its resources. OSHA currently has fewer inspectors on staff than any time in the agency's almost 50-year history. Under current funding levels, it would take OSHA 165 years to inspect each workplace within its jurisdiction. It is in everyone's interest, employers and workers, that OSHA focus its limited resources on workplaces where there are problems. And it doesn't serve anyone's interest for OSHA to be blindly inspecting workplaces, wasting their time and the time of employers by inspecting workplaces where there aren't any safety problems. Again, it just makes sense to provide OSHA with all of the information that they need to better target their inspections. In addition to targeting inspections, this information will help OSHA target its compliance assistance efforts, track trends, and evaluate the effectiveness of the standard. Why would anyone be opposed to providing the agency with the information that it needs to evaluate whether its standards are effective or not? This is not a burdensome requirement. The bill already requires the preparation of the summary in a template prepared by the secretary. There's no additional burden in providing this information to the secretary aside from just hitting send in their email. This is also not a new idea. Cal OSHA already has similar requirements, and thousands of incidents are being reported to the agency each year. The Cleveland Clinic, which tracks incidents throughout its system and reports that it confiscated a staggering 30,000 weapons from patients and visitors in the Northeast Ohio region in 2018. I can't think of no better example of why we need this requirement. I urge the gentleman's amendment be defeated, and I yield back my time, Mr. Chair.
Gentlelady's time has expired. The other comments, gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. Our colleagues have complained that solutions for workplace violence weren't addressed for 8 years under the Obama administration, but they now seek to halt H.R. 1309 in its tracks. This amendment, in the nature of a substitute, just kicks the can down the road and guts this bill. This amendment removes the interim final standard. It removes the deadline for final standard. It allows for exclusion of direct care employees in creation of the violence prevention plan. But most importantly, and not even mentioned by my colleague, Mr. Byrne, it quietly removes anti-retaliation provisions, reverting them to current inadequate protections for whistleblowers under OSHA's Section 11C. The current Section 11C anti-retaliation provisions are weak and outdated. Under 11C, employees must first file a complaint. Employees who do not file a formal complaint must still be protected if they identify incidents of workplace violence or speak out against it. Section 11C does not do that. Healthcare and social service employees are often discouraged from reporting assaults. This bill, 1309, ensures that employees who report a workplace violence incident, threat, or concern are protected from retaliation. The amendment, in the nature of a substitute, quietly removes that provision. Mr. Chairman, every failure to report increases the risk of future harm in the workplace setting. We must be encouraging reporting, and I urge a no vote on this amendment. Thank you. I yield back.
Are there other comments, gentleman from Michigan?
Mr. Chairman, thank you. Appreciate those concerns, but we agree it is important to protect employees from retaliation for reporting a violent incident or injury to their employer. However, H.R. 1309 would allow government bureaucrats to investigate what they believe is potential retaliation without any actual complaint. Employers should not have to defend themselves when there has been no complaint. The Republican amendment maintains protection for employees under the OSHA Act, Section 11C. Retaliation is already addressed in the OSHA Act under Section 11C, and employees have the right to pursue complaints alleging retaliation. Those are the facts of the case right now, and again, I would say the alternative that is being offered right now at least has the chance to have a bipartisan agreement and ultimately be signed into law, whereas the present proposal that my friends on the other side of the aisle are pushing forward will never make law. And so it won't impact employees the way we want to see them impacted and their security protected. Thank you. I yield back.
Thank you. The other comments, if not, I recognize myself to strike the last word. One of the purpose of the roster was to make sure that we would have access to potential amendments so they can be seriously considered. This was not on the roster. It was, best I can determine, offered, or at least given to us well into the markup, and it's very difficult under those circumstances to give it serious consideration. The other, I yield back. The other comments? Gentlelady from Florida. Recognized for 5 minutes. Strike the last word.
I move to strike the last word.
Gentlelady is recognized, 5 minutes.
I oppose the amendment to the nature of the substitute. And sadly, healthcare and social service workers face severely heightened risk of workplace violence. These employees have challenging but extremely important jobs that can be made safer through responsible planning and preventive measures. According to the Bureau of Labor Statistics, healthcare and social service workers are 5 times more likely to suffer a workplace injury than employees in other sectors. They face serious risk of being assaulted by patients or clients. Among some specialties, this risk is especially acute. State mental health and substance abuse social workers experience among the very highest rates of assault-related injury. 70% of psychiatric hospital workers have been physically assaulted in the past year, and in general, public employees face greater incident rates. In 2017, state government health care and social service workers were almost 9 times more likely to sustain a workplace injury. And data from the Bureau of Labor Statistics suggests this problem is getting worse. Workplace violence in these sectors have risen by 158% between 2008 and 2017 alone, and there is reason to believe incidents are being underreported. Congress can make conditions for health care and social service workers safety, which is precisely what H.R. 1309 does. The Workplace Violence Prevention for Health Care and Social Service Workers Act would require covered employers to develop a violence prevention plan. Additionally, employers and employees would work together to identify hazards, which would help employers develop tailored interventions to reduce risk. Taking small steps like ensuring adequate exit routes, distributing personal alarm devices, and installing surveillance monitoring systems can have a major impact on reducing workplace violence. H.R. 1309 would also require employers to provide annual trainings to their workers and investigate individual incidents of violence. Healthcare and social service workers need strong federal standards to help ensure that they can carry out their important jobs safely. They are counting on us to act to help put in place timely interventions to avoid future workplace violence. I urge my colleagues to join me in supporting the Workplace Violence Prevention for Healthcare and Social Services Act, which treats this issue with the seriousness it deserves, and oppose the amendment in the nature of a substitute. I yield back.
Gentlelady yields back. Are there other comments? If not, the gentlelady from Oregon on the
Mr. Chairman, I withdraw the point of order.
point of order is withdrawn. The question is now on the amendment in the nature of a substitute, to the amendment in the nature of a substitute. All in favor of the amendment will say aye.
Aye.
All opposed, no. No.
Mr. Chairman,
Gentleman from Alabama.
I request a roll call vote.
Roll call is requested, and that will be rolled with the others. Are there other amendments? If not, we will suspend and move now to H.R. 397. Committee will now proceed with the consideration of H.R. 397 for amendment. The bill was circulated in advance and printed copies are available. The clerk will designate the bill.
H.R. 397, to amend the Internal Revenue Code of 1986 to create a pension rehabilitation trust fund, to establish a pension rehabilitation administration within the Department of the Treasury, to make loans to multi-employer defined benefit plans and for other purposes.
Without objection, the first reading of the bill is dispensed with, and the motion that I now introduce an amendment in the nature of a substitute. The bill will now be considered as read and be open to amendment at any point. Any amendment offered shall be considered as read.
Mr. Chairman,
Mr.
I
Chairman.
object to considering any amendment offered as read.
Let me offer the amendment in nature for substitute first. The I offered the amendment in nature of a substitute, and clerk will designate the amendment,
Amendment in
and
the,
then we will consider the objection.
amendment in the nature of a substitute to H.R. 397, offered by Mr. Scott of Virginia.
Okay, the amendment is, without objection, the amendment is considered as read.
Mr. Chairman, I object to considering any amendment offered as read.
Okay, the objection to the amendment being read, the clerk shall read the amendment in nature of a substitute, and as a courtesy to members, I will notify staff to call the members and let them know that at the end of the reading of the amendment in nature of a substitute, we will proceed to a motion on the previous question and final passage of the bill. Clerk will proceed.
Amendment in the nature of a substitute to H.R. 397, offered by Mr. Scott of Virginia. Strike all after the enacting clause and insert the following. Section 1, short title, this act may be cited at the Rehabilitation for Multi-Employer Pensions Act of 2019. Section 2, Pension Rehabilitation Administration, Establishment Powers. A, establishment. There is established in the Department of the Treasury an agency to be known as the Pension Rehabilitation Administration. B, director. 1, establishment of position. There shall be at the head of the Pension Rehabilitation Administration a director who shall be appointed by the president. 2, term. A, in general, the term of office of the director shall be 5 years. B, service until appointment of successor, an individual serving as director at the expiration of a term may continue to serve until a successor is appointed. 3, powers. A, appointment of deputy directors, officers, and employees. The director may appoint deputy directors, officers, and employees, including attorneys, in accordance with Chapter 51 and Subchapter 3 of Chapter 50 of Title 5 United States Code. B, contracting. I, in general, the director may contract for financial and administrative services, including those related to budget and accounting, financial reporting, personnel, and procurement of general services administration or such other federal agency as the director determines appropriate, for which payment shall be made in advance or by reimbursement from funds of the Pension Rehabilitation Administration in such amounts as may be agreed upon by director and the head of the federal agency providing the services. 2, subject to appropriations, contract authority under Clause I shall be effective for any fiscal year only the extent that appropriations are available for that purpose. C, transfer of funds. The Secretary of the Treasury may transfer for any fiscal year from unobligated amounts appropriated to the Department of the Treasury to the Pension Rehabilitation Administration such sums as may be reasonably necessary for the administrative and operating expenses of Pension Rehabilitation Administration. Section 3, Pension Rehabilitation Trust Fund. A, in general, Subchapter A of Chapter 98 of the Internal Revenue Code of 1986 is amended by adding at the end of the following new section. Section 9512, Pension Rehabilitation Trust Fund. A, creation of trust fund. There is established in the Treasury of the United States a trust fund to be known as the Pension Rehabilitation Trust Fund, hereafter in this section referred to as the fund, consisting of such amounts as may be appropriated or credited to the fund as provided in this section in Section 9602B. B, transfers to fund. 1, amounts attributable to Treasury bonds. There shall be credited to the funds the amount transferred under Section 6 of Rehabilitation for Multi-Employer Pensions Act of 2019. 2, loan interest and principal. A, in general, the director of the Pension Rehabilitation Administration established under Section 2 of the Rehabilitation for Multi-Employer Pensions Act of 2019 shall deposit in the fund any amounts received from a plan as payment of interest or principal on a loan under Section 4 of such act. B, interest. For purposes of subparagraph A, the term interest includes points and other similar amounts. 3, transfers from secretary. The director of the Pension Rehabilitation Administration shall deposit in the fund any amounts received from the secretary under Section 2C of such act. 4, availability of funds. Amounts credited to or deposited in the fund shall remain available until expended. C, expenditures from fund. Amounts in the fund are available without further appropriation in the Pension Rehabilitation Administration. 1, for the purpose of making the loans described in Section 4 of the Rehabilitation for Multi-Employer Pensions Act of 2019. 2, for the payment of principal and interest of obligations issued under Section 6 of such act. And 3, for administrative and operating expenses of such administration. B, clerical amendment. The table of sections for Subchapter A of Chapter 98 of the Internal Revenue Code of 1986 is amended by adding at the end of the following new items. Section 9512, Pension Rehabilitation Trust Fund. Section 4, Loan Program for Multi-Employer Defined Benefit Plans. A, loan authority. 1, in general, the Pension Rehabilitation Administration established under Section 2 is authorized, A, to make loans to multi-employer plans as defined in Section 414F of the Internal Revenue Code of 1986, which are defined benefit plans as defined in Section 414J of such code, and which I are in critical and declining status within the remaining section, the meaning of Section 432B6 of such code and Section 305B6 of such act, as of the day of the enactment of this act, or with respect to which a suspension of benefits has been approved under Section 432C9 of such code and Section 305E9 of such act as of such date. 2, as of such day of enactment are in critical status within the meaning of the Section 432B2 of such code and Section 305B2 of such act, have a funded percentage of less than 40% as determined by purposes of Section 432 of such code and Section 305 of such act, and have a ratio of active to inactive participants which is less than 2 to 3, or 3, are insolvent for purposes of Section 418E of such code of such date of enactment, if they become insolvent after December 16, 2014, and have not been terminated, and B, subject to subsection B, to establish appropriate terms for such loans. 2, consultation. The Director of the Pension Rehabilitation Administration shall consult with Secretary of the Treasury, the Secretary of Labor, the Director of the Pension Benefit Guaranty Corporation before making any loan under paragraph 1, and shall share with such persons the application and plan information with respect to each such loan. 3, establishment of loan program. A, in general, a program to make the loans authorized under this section shall be established not later than September 30th, 2019, with guidance regarding such programs to be promulgated by the Director of the Pension Rehabilitation Administration in consultation with the Pension Benefit Guaranty Corporation and the Department of Labor not later than December 31st, 2019. B, loans authorized before program date. Without regard to whether the program under subparagraph A has been established, a plan may apply for a loan under this section before either date described in such subparagraph, and the Pension Rehabilitation Administration shall approve the application and make the loan before establishment of the program if necessary to avoid any suspension of the accrued benefits of participants. B, loan terms. 1, in general, the terms of any loan made under subsection A shall state that A, the plan shall make payments of interest on the loan for a period of 29 years beginning on the date of the loan, or 19 years in the case of a plan making the election under subsection C5. B, final payment of interest and principal shall be due in the 30th year after the date of the loan, except as provided in an election under subsection C5 and C. As a condition of the loan, the plan sponsor stipulates that I accept as provided in clause 2, the plan will not increase benefits or allow any employer participating in the plan to reduce its contributions or accept any collective bargaining agreement which provides for reduced contribution rates during the 30-year period described in subparagraphs A and B. 2, in the case of a plan with respect to which a suspension of benefits have been approved under Section 432E9 of the Internal Revenue Code of 1986 and Section 305E9 of the Employee Retirement and Income Security Act of 1974, or under Section 418E of such code before the loan, the plan will reinstate the suspended benefits or will not carry out any suspension which has been approved but not yet implemented. 3, the plan sponsor will comply with the requirements of Section 6059A of the Internal Revenue Code of 1986. 4, the plan will continue to pay all premiums due under Section 4007 of the Employee Retirement Income Security Act of 1974. And 5, the plan and plan administrator will meet such other requirements as the Director of the Pension Rehabilitation Administration provides in the loan terms. The terms of the loan shall not make reference to whether the plan is receiving financial assistance under Section 4261D of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1431D, or to any adjustment of the loan under subsection D2A to 2 interest rate, except as provided in the second sentence of this paragraph. And subsection C5, loans made under subsection A shall have as low an interest rate as is feasible. Such rate shall be determined by the Pension Rehabilitation Administration, and shall A, not be lower than the rate of interest on 30-year Treasury securities on the first day of the calendar year in which the loan is issued, and B, not exceed the greater of 1, a rate 0.2% higher than such rate of interest on such date, or 2, the rate necessary to collect revenue sufficient to administer the program in this section. C, loan application. 1, in general, in applying for a loan under subsection A, the plan sponsor shall A, demonstrate that accept all provided in subparagraph C, One, the loan will enable the plan to avoid insolvency for at least the 30-year periods described in subparagraphs A and B of subsection B1, or in case of a plan which is already insolvent, to emerge from insolvency within and avoid insolvency for the remainder of such period. And two, the plan is reasonably expected to be able to pay benefits and the interest on the loan during such period and to accumulate sufficient funds to repay principal when due. B, provide the plan's most recently filed Form 5500 as the date of application and any other information necessary to determine the loan amount under subsection D. C, stipulate whether the plan is also applying for financial assistance under section 4261D of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1431D, in combination with the loan to enable the plan to avoid insolvency and to pay benefits, or is already receiving such financial assistance as a result of a previous application. D, state in what matter the loan proceeds will be invested pursuant to subsection D. The person from whom any annuity contracts under such subsection will be purchased, and the person who will be the investment manager for any portfolio implemented under such subsection. And E, includes such other information and certifications as the Director of the Pension Retirement Rehabilitation Administration shall require. 2, standard for accepting actuarial and plan sponsor determinations and demonstrations in the application. In evaluating the plan sponsor's application, Director of the Pension Rehabilitation Administration shall accept the determinations and demonstrations in the application unless the Director, in consultation with the Director of the Pension Benefit Guarantee Corporation, the Secretary of Labor, concludes that the determinations and demonstrations in the application are unreasonable or inconsistent with any rules issued by the Director pursuant to subsection G. 3, require actions deemed approval. The Director of the Pension Rehabilitation Administration shall approve or deny any application under this subsection within 90 days after the submission of such application. An application shall be deemed approved unless within such 90 days the Director notifies the plan sponsor of the denial of such application and the reasons for such denial. Any approval or denial of an application by the Director of the Pension Rehabilitation Administration should be treated as a final agency action for purposes of Section 704 of Title V United States Code. The Pension Rehabilitation Administration shall make the loan pursuant to any application promptly after approval of such application. 4, certain plans required to apply. The plan sponsor of any plan with respect to which a suspension of benefits has been approved under Section 432E9 of the Internal Revenue Code of 1986 and Section 305E9 of the Employee Retirement Income Security Act of 1974 under Section 418E of such code before the day of the enactment of this act shall apply for a loan under this section. The Director of the Pension Rehabilitation Administration shall provide for such plan sponsors to use a simplified application under Section D2B. 5, incentive for early repayment. The plan sponsor may elect at the time of the application to repay the loan principal, along with remaining interest over the 10-year period beginning at the 21st year of the date of the loan. In the case of a plan making this election, the interest on the loan shall be reduced by 0.5%. D, loan amount in use. 1, amount of loan. A, in general, except as provided in subparagraphs B and C and paragraph 2, the amount of any loan under subsection A shall be as demonstrated by the plan sponsor on the application under subsection C, the amount needed to purchase annuity contracts or to implement a portfolio described in paragraph 3C or a combination of the two, sufficient to provide benefits of participants and beneficiaries of the plan in paid status and terminate vested benefits at the time the loan is made. B, limitation based on ability to repay. If at the time of the application under subsection C, the plan sponsor determines that based on a repayment schedule that would provide for repayment of the full amount determined under subparagraph A or C, 2, within the 30-year period described in subsection B1, making payments would cause the plan to be within 18 months of becoming insolvent at any point during such period, the loan amount shall be such lesser amount as the plan sponsor determines that the plan will be able to repay without becoming within 18 months of insolvency. C, plans with suspended benefits. In the case of a plan with respect to which a suspended benefits has been approved under Section 432E9 of the Internal Revenue Code of 1986 and Section 305E9 of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1085E9 under Section 418E of such code. 1, the suspension of benefits shall not be taken into account in applying subparagraph A, and 2, except as provided in subparagraph B, the loan amount shall be the amount sufficient in provided benefits of participants and beneficiaries of the plan and pay status and terminated vested benefits at the time the loan is made, determined without regard to the suspension, including retroactive payment of benefits which will otherwise have been payable during the period of the suspension. 2, coordination with PBGC financial assistance. A, in general, in the case of a plan which is also a applying for financial assistance under Section 4261D of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1431D. 1, the plan sponsor shall submit the loan application and the application for financial assistance jointly to the Pension Rehabilitation Administration and the Pension Benefit Guaranty Corporation with the information necessary to determine the eligibility for an amount of the loan under this section and the financial assistance under Section 4261D of such act. And 2, if such financial assistance is granted, the amount of the loan under subsection A shall not exceed an amount equal to excess of 1, the amount under paragraph 1A or 1C, 2, whichever is applicable without regard to paragraph 1B, over 2, the amount of such financial assistance. B, plans already receiving PBG assistance. The Director of the Pension Rehabilitation Administration shall provide for a simplified application for the loan under this section, which may be used by an insolvent plan which has not been terminated and which is already receiving financial assistance other than under Section 4261D of such act from the Pension Benefit Guaranty Corporation at the time of the application for the loan under this section. 3, use of loan funds. A, in general, the loan received under subsection A shall be used to purchase annuity contracts which meets the requirements of subparagraph B, or to implement a portfolio described in subparagraph C, or a combination of the two to provide the benefits described in paragraph 1. B, annuity contracts requirements. Annuity contracts purchased under subparagraph A shall be issued by an insurance company which is licensed to do business under the laws of any state and which is rated A or better by a nationally recognized statistical rating organization, and the purchase of such contract shall meet all applicable fiduciary standards under the Employee Retirement Income Security Act of 1974. See portfolio. 1, in general, a portfolio described in this subparagraph is 1, a cash matching portfolio or duration matching portfolio consisting of investment grade as rated by a nationally recognized statistical rating organization, fixed income investments, including United States dollar denominated public or private debt obligations issued or guaranteed by the United States or a foreign issuer, which are tradable in United States currency and are issued at fixed or zero coupon rates. 4, 2, any other portfolio prescribed by the Secretary of the Treasury and regulations which has a similar risk profile to the portfolios described in subclause 1 and is equally protective of the interests of participants and beneficiaries. Once implemented, such a portfolio shall be maintained under all liabilities to participants and beneficiaries in pay status at the time of the loan are satisfied. 2, fiduciary duty. Any investment manager of a portfolio under this subparagraph should acknowledge in writing that such person is a fiduciary under the Employee Retirement Income Security Act of 1974 with respect to the plan. 3, treatment of participants and beneficiaries. Participants and beneficiaries covered by a portfolio under this subparagraph shall continue to be treated as participants and beneficiaries of the plan, including for purposes of Title IV of the Employee Retirement Income Security Act of 1974. D, accounting. 1, in general, annuity contracts purchased and portfolios implemented under this section shall be used solely to provide the benefits described in paragraph 1 until all such benefits have been paid and shall be accounted for separately from the other assets of the plan. 2, oversight of non-annuity investments. 1, in general, any portfolio implemented under this paragraph should be subject to oversight by the Pension Rehabilitation Administration, including a mandatory triennial review of the adequacy of the portfolio to provide the benefits described in paragraph 1. Approval to be provided within a reasonable period of time of any decision by the plan sponsor to change the investment manager of the portfolio. 2, remedial action. If the triennial review under subclause 1 determines an inadequacy, the plan sponsor shall take remedial action to ensure that inadequacy will be cured within 5 years of the review. E, ombudsperson. The participant and plan sponsor advocate established under Section 4004 of the Employee Retirement Income Security Act of 1974 shall act as ombudsperson for participants and beneficiaries on behalf of whom annuity contracts are purchased or who are covered by a portfolio under this paragraph. E, collection of repayment. Except as provided in subsection F of the Pension Rehabilitation Administration shall make every effort to collect repayment of loans under this section in accordance with Section 3711 of Title 31 United States Code. F, loan default. If a plan is unable to make any payment on a loan under this subsection when due, the pension Pension Rehabilitation Administration shall negotiate with the plan sponsor revised terms for repayment, including installment payments over a reasonable period or forgiveness of a portion of the loan principal, but only to the extent necessary to avoid insolvency in the subsequent 18 months. G, authority to issue rules, etc. The Director of the Pension Rehabilitation Administration is in consultation with the Pension Benefit Guarantee Corporation and the Department of Labor, is authorized to issue rules regarding the form, content, and process of applications for loans under this section, actuarial standards and assumptions to be used in making estimates and projections for purposes of such applications, and assumptions regarding interest rates, mortality, and distributions with respect to a portfolio described in subsection D3C. H, coordination with taxation of unrelated business income, subparagraph A of section 514C6 of the Internal Revenue Code of 1986 is amended. 1, by striking or at the end of clause 1, 2, by striking the period at the end of clause 2, and inserting or, and 3, by adding at the end of the following new clause. 3, indebtedness. With respect to a multi-employer plan under a loan may be made by the Pension Rehabilitation Administration pursuant to Section 4 of the Rehabilitation for Multi-Employer Pensions Act of 2019. Section 5, coordination with withdrawal liability and funding rules. A, amendment to Internal Revenue Code of 1986, Section 432 of the Internal Revenue Code of 1986 is amended by adding at the end of the following new subsection. K, special rules for plans receiving pension rehabilitation loans. 1, determination of withdrawal liability. A, in general, if any employer participating in a plan at the time the plan receives a loan under Section 4A of the Rehabilitation for Multi-Employer Plans Act of 2019 withdraws from the plan before the end of the 30-year period beginning at the date of the loan, the withdrawal liability of such employer should be determined under the Employee Retirement Income Security Act of 1974. 1, by applying Section 4219C1D of the Employee Retirement Income Security Act of 1974 as if the plan were terminated by the withdrawal of every employer from the plan, and 2, by determining the value of non-forfeitable benefits under the plan at the time of the deemed termination by using the interest assumptions prescribed for purposes of Section 4044 of the Employee Retirement Income Security Act of 1974 as prescribed in the regulations under Section 4281 of the Employee Retirement Income Security Act of 1974 in the case of such a mass withdrawal. B, annuity contracts and investment portfolios purchased with loan funds. Annuity contracts purchased and portfolios implemented under Section 4D3 of the Rehabilitation for Multi-Employer Pensions Act of 2019 shall not be taken into account in determining the withdrawal liability of any employer under subparagraph A, but the amount equal to the greater of 1, the benefit provided under such contracts or portfolios to participants and beneficiaries, or 2, the remaining payments due on the loan under Section 4A of such act shall be so taken into account. 2, coordination with funding requirements. In the case of a plan which receives a loan under Section 4A of the Rehabilitation for Multi-Employer Pension Act of 2019, A, annuity contracts purchased and portfolios implemented under Section 4D3 of such act and the benefits provided to participants and beneficiaries under such contracts or portfolios shall not be taken into account in determining minimum required contributions under Section 412. B, payments on the interest and principal under the loan or and any benefit owed in excess of those provided under such contracts or portfolios shall be taken into account as liabilities for purposes of such section. And C, if such a portfolio is projected due to unfavorable investment or actuarial experience to be unable to fully satisfy the liabilities which it covers, the amount of the liabilities projected to be unsatisfied shall be taken into account as liabilities for purposes of such section. B, amendment to Employee Retirement Income Security Act of 1974. Section 305 of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1085 is amended by adding at the end of the following new subsection. K, special rules for plans receiving pension rehabilitation loans. 1, determination of withdrawal liability. A, in general, if any employer participating in a plan that at the time the plan receives a loan under Section 4A of the Rehabilitation for Multi-Employer Pensions Act of 2019 withdraws from the plan before the end of the 30-year period beginning at the date of the loan, the withdrawal liability of such employer shall be determined. 1, by applying Section 4219C1D as if the plan were terminating by the withdrawal of every employer from the plan, and 2, by determining the value of non-forfeitable benefits under the plan at the time of the deemed termination by using the interest assumptions prescribed by purposes of Section 4044 as prescribed in the regulations under Section 4281 in case of such a mass withdrawal. B, annuity contracts and investment portfolios purchased with loan funds, annuity contracts purchased and portfolios implemented under Section 4D3 of the Rehabilitation for Multi-Employee Pensions Act of 2019 shall not be taken into account in determining the withdrawal liability of any employer under subparagraph A, but the amount equal to the greater of 1, the benefits provided under such contracts or portfolios to participants and beneficiaries, or 2, the remaining payments due on the loan under Section 4A of such act shall be so taken into account. 2, coordination with funding requirements. In the case of a plan which receives a loan under Section 4A of the Rehabilitation for Multi-Employer Pensions Act of 2019, A, annuity contracts purchased and portfolios implemented under Section 4D3 of such act, and the benefits provided to participants and beneficiaries under such contracts or portfolios shall not be taken into account in determining minimum required contributions under Section 302. B, payments on the interest and principal under the loan and any benefits owed in excess of those provided under such contracts or portfolios shall be taken into account as liabilities for purposes of such section. And C, if such a portfolio is projected due to unfavorable investment or actuarial experience to be unable to fully satisfy the liabilities which it covers, the amount of the liabilities projected to be unsatisfied shall be taken into account as liabilities for purposes of such section. Section 6, issuance of treasury bonds. The Secretary of the Treasury, in consultation with the Director of the Pension Rehabilitation Administration established under Section 2, shall from time to time transfer from the general fund of the Treasury to the Pension Rehabilitation Trust Fund established.
Mr. Chairman, I make a point of order that a quorum's not present.
The clerk will call the roll.
Chairman Scott.
Present.
Chairman Scott's present. Mrs. Davis. Mr. Grijalva. Mr. Grijalva is present. Mr. Courtney. Mr. Courtney is present. Ms. Fudge. Mr. Sablon. Ms. Wilson. Ms. Bonamici. Ms. Bonamici is present. Mr. Takano. Mr. Takano is present. Ms. Adams. Ms. Adams is present. Mr. DeSaulnier. Mr. DeSaulnier is present. Mr. Norcross. Mr. Norcross is present. Ms. Jayapal. Mr. Morelli. Mr. Morelli is present. Ms. Wild. Ms. Wild is present. Mr. Harder. Mr. Harder is present. Mrs. McBath. Mrs. McBath is present. Ms. Schreier. Ms. Schreier is present. Ms. Underwood. Ms. Underwood is present. Mrs. Hayes. Ms. Shalala. Mr. Levin. Mr. Levin is present. Ms. Omar. Ms. Omar is present. Mr. Trone. Mr. Trone is present. Ms. Stevens. Ms. Stevens is present. Mrs. Lee. Mrs. Lee is present. Mrs. Trahan. Mrs. Trahan is present. Mr. Castro. Mrs. Fox.
Present.
Mrs. Fox is present. Mr. Rowe. Mr. Rowe is present. Mr. Thompson. Mr. Wahlberg. Mr. Wahlberg is present. Mr. Guthrie. Mr. Byrne. Mr. Grothman. Mr. Stefanik. Mr. Allen. Mr. Allen is present. Mr. Rooney. Mr. Smucker. Mr. Banks. Mr. Walker? Mr. Comer? Mr. Klein? Mr. Fulcher? Mr. Taylor? Mr. Taylor is present. Mr. Watkins? Mr. Wright? Mr. Muser? Mr. Muser is present. Mr. Timmons? Mr. Johnson?
How is Mr. Thompson recorded, Mr. Chairman?
Mr. Thompson?
Mr. Thompson is not recorded. Mr. Thompson is present.
How is Mr. Guthrie reported, Mr. Chairman?
Mr. Guthrie is present.
Mr. Grothman, Mr. Chairman?
Mr. Grothman is present.
How is Ms. Stefanik recorded, Mr. Chairman?
Ms. Stefanik is present.
How is Mr. Rooney recorded, Mr. Chairman?
Mr. Rooney is present.
How is Mr. Muser recorded, Mr. Chairman?
Mr. Muser is recorded as present.
Ms. Jayapal?
Ms. Jayapal is present.
Clerk will report.
Excuse me, Mr. Chairman, how's Mr. Comer recorded?
Ms. Comer?
Mr. Comer is not recorded. Mr. Comer is present.
Ms. Fudge?
Ms. Fudge is present.
Ms. Hayes?
Ms. Hayes is present.
Ms. Wilson?
Ms. Wilson is present.
The clerk will report.
Chairman, how's Mr. Timmons recorded? I'm sorry, Mr. Watkins.
Mr. Watkins?
Mr. Watkins is not recorded. Mr. Watkins is present.
Mr. Chairman, how's Mr. Johnson recorded?
Mr. Johnson?
Mr. Johnson is present. Mr. Johnson is present.
Is Ms. Shalala recorded? Okay.
Ms. Shalala is present.
Is Mr. Castro recorded?
Mr. Castro is present.
Is Mr. Timmons recorded?
Mr. Timmons is not recorded. Mr. Timmons is present.
Clerk will report.
Mr. Chairman, 41 members are present.
Quorum is present. Clerk will continue to read.
Section 6, issuance of treasury bonds. The Secretary of the Treasury, in consultation with the Director of the Pension Rehabilitation Administration established under Section 2, shall from time to time transfer from the general fund of the Treasury to the Pension Rehabilitation Trust Fund established under Section 9512 of the Internal Revenue Code of 1986 such amounts as are necessary to fund the loan program under Section 4 of this Act, including from proceeds from the Secretary's issuance of obligations under Chapter 31 of Title 31, United States Code. Section 7, reports of plans receiving pension rehabilitation loans. A, in general, subpart E of Part 3 of subchapter A of Chapter 61 of the Internal Revenue Code of 1986 is amended by adding at the end of the following new section. Section 6059A, reports on plans receiving pension rehabilitation loans. A, in general, in the case of a plan receiving a loan under Section 4A of the Rehabilitation for Multi-Employer Pensions Act of 2019 with respect to the first plan year beginning after the date of the loan and each of the 29 succeeding plan years not later than the 90th day of each such plan year, the plan sponsor shall file with the Secretary of report, including appropriate documentation and actuarial certifications from the plan actuary as required by the Secretary. That contains 1, the funded percentage as defined in Section 43212 as the first day of such plan year and the underlying actuarial value of assets determined with regard and without regard to annuity contracts purchased and portfolios and implemented with proceeds of such loan, and liabilities including any amount due with respect to such loan taken into account in determining such percentage. 2, the market value of the assets of the plan determined as provided in paragraph 1 as of the last day of the plan year preceding such plan year. 3, the total value of all contributions made by employers and employees during the plan year preceding such plan year. 4, the total value of all benefits paid during the plan year preceding such plan year. 5, cash flow projections for such plan year and the 9 succeeding plan years and assumptions used in making such projections. 6, funding standard account projections for such plan year and the 9 succeeding plan years and the assumptions relied upon in making such projections. 7, the total value of all investment gains or losses during the plan year preceding such plan year. 8, any significant reduction in the number of active participants during the plan year preceding such plan year and the reason for such reduction. 9, a list of employers that withdrew from the plan in the plan year preceding such plan year, the resulting reduction in contributions. 10, a list of employers that paid withdrawal liabilities to the plan during the plan year preceding such plan year, and for each employer, total assessment of the withdrawal liability paid, the annual payment amount, and the number of years remaining in the payment schedule with respect to such withdrawal liability. 11, any material changes to benefits, actual accrual rates, or contribution rates during the plan year preceding such plan year, whether such changes relate to the terms of the loan. 12, details regarding any funding improvement plan or rehabilitation plan and updates to such plan. 13, the number of participants and beneficiaries during the plan year preceding such plan year who are active participants, the plan of participants and beneficiaries in pay status, and the number of terminated vested participants and beneficiaries. 14, the amount of any financial assistance received under Section 4261 of the Employee Retirement Income Security Act of 1974 to pay benefits during the preceding plan year and the total amount of such financial assistance received for all preceding years. 15, the information contained on the most recent annual funding notice submitted by the plan under Section 101F of the Employee Retirement Income Security Act of 1974. 16, the information contained on the most recent annual return under Section 6058 and actuarial report under Section 6059 of the plan, and 17, copies of the plan document and amendments, other retirement benefit or ancillary benefit plans relating to the plans and contribution obligations under such plans, a breakdown of administrative expenses of the plan, participant census data, and distribution of benefits, the most recent actuarial valuation report as of the plan year, copies of collective bargaining agreements and financial reports, and such other information as the Secretary in consultation with the Director of the Pension Rehabilitation Administration may require. B, electronic submission. The report required under Section A shall be submitted electronically. C, information sharing. The Secretary shall share the information in the report under Section A with the Secretary of Labor and the Director of the Pension Benefit Guarantee Corporation. 33D, D, report to participants, beneficiaries, and employers. Each plan sponsor required to file a report under subsection A shall, before the expiration of the time prescribed for the filing of such report, also provide a summary written in a manner so as to be understood by the average plan participant of the information in such report to participants and beneficiaries in the plan and to each employer with an obligation to contribute to the plan. Penalty, subsections E of Section 6652 of the Internal Revenue Code of 1986 is amended. 1, by inserting 6059A relating to reports of plans receiving pension rehabilitation loans after deferred compensation. 2, by inserting $100 in the case of failures under Section 6059A after $25. And 3, by adding at the end of the following, in the case of a failure with respect to Section 6059A, the amount imposed under this subsection shall not be paid from the asset of the plan. C, clerical amendment. The table of sections from Subpart E of Part 3 of Subchapter A of Chapter 61 of the Internal Revenue Code of 1986 is amended by adding at the end of the following new item. Section 6059A, reports of plans receiving pension rehabilitation loans. Section 8, PBGC financial assistance. 8, in general, Section 4261 of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1431 is amended by adding at the end of the following new subsection. D, 1, the plan sponsor of a multi-employer plan, A, which is in critical and declining status within the meaning of Section 305B6 as of the date of the enactment of this subsection, or with respect to which a suspension of benefits has been approved under Section 305E9 of such date. B, which as of such date of enactment is in critical status within the meaning of Section 305B2 has a funded percentage of less than 40% as determined for purposes of Section 305 and has a ratio of active to inactive participants which is less than 2 to 3, or C, which is insolvent for purposes of Section 41AE of the Internal Revenue Code of 1986 as of such date of enactment. If the plan became insolvent after December 16, 2014, has not been terminated, and which is applying for a loan under Section 4A of the Rehabilitation for Multi-Employer Pension Act of 2019 may also apply to the corporation for financial assistance under this subsection by jointly submitting such applications in accordance with Section 4D2 of such act. Application for financial assistance under this subsection shall demonstrate based on projections by the plan actuary that after the receipt of the anticipated loan amount under Section 4A of such act, the plan will still become or remain insolvent within the 30-year period beginning on the date of the loan. 2, in reviewing application under paragraph 1, the corporation shall review the demonstrations and assumptions submitted with the loan application under Section 4C of the Rehabilitation for Multi-Employer Pensions Act of 2019 and provide guidance regarding such assumptions prior to approving any application for financial assistance under this subsection. The corporation may deny any application if the assumption and determinations are unreasonable or inconsistent with rules issued by the corporation, and the plan and the corporation are unable to reach agreement on such assumptions and determinations. 3, in the case of a plan described in paragraph 1A or 1B, the financial assistance provided pursuant to such application under this subsection shall be to the amount determined by the plan actuary and submitted under the plan equal to the sum of A, the percentage of benefits of participants and beneficiaries of the plan and pay status at the time of the application, and B, the percentage of future benefits to which participants have separated from service but are not yet in pay status are entitled, which if such percentage were paid by the corporation in combination with the loan would allow the plan to avoid projected insolvency. Such amount shall not exceed the maximum guaranteed benefit with respect to all participants and beneficiaries of the plan under sections 4022A and 4022B. For this purpose, the maximum guaranteed benefit amount shall be determined by discarding any loan available from the Pension Rehabilitation Administration and shall be determined as if the plan were insolvent on the day of the application. Further, the present value of the maximum guaranteed benefit amount with respect to such participants and beneficiaries may be calculated in the aggregate rather than by reference to the benefit of such participant or beneficiary. 4, in the case of a plan described in paragraph 1C, the financial assistance provided pursuant to such application under this subsection shall be the amount determined by the plan actuary and submitted on the application, which if such amount were paid by the corporation in combination with the loan and any other assistance being provided to the plan by the corporation at the time of the application will enable the plan to emerge from the projected insolvency. 5A, except as provided in subparagraph B, the corporation shall provide the financial assistance under this subsection only in such amounts as the corporation determines at the time of approval and at the beginning of each plan year beginning and thereafter during the period of assistance are necessary for the plan to avoid insolvency during the 5-plan year period beginning with the current plan year. B, in the case of a plan described in paragraph 1C, the financial assistance under this subsection should be provided in a lump sum if deemed necessary by the corporation and in no case later than December 31st, 2020. 6, subsections B and C shall apply to financial assistance under this subsection as if it were provided under subsection A, except that the terms for repayment under subsection B2 shall not require the financial assistance to be repaid before the date on which the loan under Section 4A of the Rehabilitation for Multi-Employer Pension Act of 2019 is repaid in full. 7, the corporation may forego repayment of the financial assistance provided under this subsection if necessary to avoid any suspension of the accrual benefits of participants. B, appropriations there is appropriated to the Director of the Pension Benefit Corporation, Pension Benefit Guarantee Corporation, such sums as may be necessary for each fiscal year to provide the financial assistance described in Section 4261D of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1431D, as added by this section, including necessary administrative and operating expenses related to such assistance.
Thank you. The bill now having been read, I recognize myself for 5 minutes. To explain what you've just heard. The amendment nature of a substitute contains core provisions from the introduced version of the bill, but includes a few substantive changes. It narrows and clarifies the loan program's eligibility to those plans that are now most in urgent need of help. It adds an alternative accelerated repayment plan for repayment schedule for loans, provides additional detail for the interest rates for loans, clarifies how the PBGC assistance is determined and provided to certain plans, and includes other clarifying and technical amendments. Here's the problem. Most of the 1,400 multi-employer pension plans in the U.S. are not in any danger of collapse, but some 130 plans covering about 1 million people are rapidly running out of money to pay for promised benefits. Some very large plans are projected to be insolvent within the next few years, and to make matters worse, the Multi-Employer Pension Insurance Fund, the PBGC, the federal agency that insures these multi-employer pension funds, will be facing insolvency if these plans are allowed to fail. The PBGC has approximately $2.3 billion in assets to meet $56 billion in near-term liabilities and will run out of funds by 2025. Now, we had many witnesses who answered the question that even if the PBGC goes broke and runs out of money, the PBGC and the federal government have a moral obligation to make good on the promises. We have received premiums, and we should fulfill our promises. So even if it goes broke, we should still be on the hook. But jobs are in jeopardy if we fail to act. One conservative economist estimated that if one major plan fails, as projected in 2025, there'd be a loss of 55,000 jobs across the United States. That's just one plan, 1 year. Some have raised objections regarding taxpayers' role in preventing the collapse of the multi-employer pension fund. But the hard truth is that taxpayers are already on the hook, whether we address the problem or not. The cost of doing nothing in terms of lost tax revenue and increased social safety net spending is estimated to be between $170 billion and $240 billion over the 10-year budget window, and between $332 billion and almost $500 billion over 30 years. And that doesn't include our moral obligation to make good on the PBGC benefits. Now, H.R. 397 was first introduced in November 2017. It's been discussed and socialized with all of the relevant stakeholders in the multi-employer pension system. It's a bipartisan bill with over 170 co-sponsors in the House and has the support of diverse coalitions, including AARP, BlackRock, the AFL-CIO, and many others. We've had legislative hearing in March. It is in a known quantity, and no one should be shocked that we're advancing it today. Yeah, the ranking member is correct that pension policy is complex and time-consuming. It's also important to note that the committee Republicans just shared amendments to our staff at 11:35 a.m. Not having seen them for now creates a challenge in evaluating the amendments' implications, and we're in the process of doing that. But keeping these amendments hidden from us until 11:35, when the markup started at 10:15, seems to suggest that their ideas have not been scrutinized nor widely supported. Bad processes like this yields bad policy over the time. We've had a select committee look at this. We've been working on this, and it's time to take action. With that, I yield to the gentlelady from North Carolina for her statement.
Thank you, Mr. Chairman. We certainly do agree that bad processes yield bad policy, and today has been an example of bad process on the part of the majority. The committee has held one hearing on the issue, neglecting to fully examine this bill in a legislative hearing. We're stunned to hear on Friday the committee be marking up a sweeping bill that hasn't received full consideration of this panel. It's simply irresponsible to bring a bill addressing such a complex and far-reaching issue before the committee for markup with only days' notice. The chairman commented on the delay in receiving amendments from committee Republicans. How can he reasonably expect committee Republicans to respond to a 38-page ANS given to us on Sunday morning with 11 provisions outside of this committee's jurisdiction? Democrats have stated they wanted to work together in a bipartisan fashion. So have we. Our friends on the other side of the aisle, however, are stopping Republicans from offering amendments. How are we supposed to work together when half of the room is barred from participating? I find it frankly embarrassing that the committee that was able to negotiate bipartisan multi-employer pension legislation in the not-so-distant past has succumbed to such tactics. I have to say, I kept saying, you mean we're going to be adopting this bill written by George Miller? And I kept being told, yes, 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 and I supported it. In the end, these politically motivated actions only delay meaningful help for the workers and retirees that are in desperate need of a solution from this body. Today, those workers were reduced to mere pawns in Speaker Pelosi's vindictive hold on the House of Representatives. Mr. Chairman, had we been allowed to, we would have offered 11 amendments. 1, the Obama-Trump premium proposal. 2, require independent trustees. 3, specified interest rate. 4, taxpayer protection. 5, adjusted guarantee to cover minors. 6, oversight. 7, responsible promises. 8, pensioners first. 9, union collateral. 10, single employer parity. And 11, actuarial integrity. I truly am disappointed, Mr. Chairman, by what has happened today in this markup. And I hope it doesn't bode poorly for the future of the committee. We began this session talking about working in a bipartisan fashion, and I, for one, am committed to continue to do that. But if we continue to do this, then I question our ability. I now would like to yield my time to Mr. Wahlberg.
I thank the gentlelady. This is a shame what's taken place here. I look at the audience out there who are being sold a sham today of something that is purportedly going to do something, that can pass, can be signed. My Central States workers in my district have stood in front of me and have given legitimate concerns. Mr. Chairman, you're better than this. We've worked together in the past. We made a commitment together on our subcommittee when we held a hearing that we would work together for a solution. We saw the Butch-Lewis plan attempted to work out during that special committee. Ultimately, they gave up. They said it wouldn't work. It couldn't work. There are things that we can work. We can make it work together. But today, to give us Sunday a 38-page document that we hadn't had a chance to read, some people are still in Normandy, a chance to look at this with 11 amendments that dealt with something we don't have a jurisdiction over. That's the tax code. And now to tell these people that this is something that's going to work for them and their brothers and sisters, it's cynical. It's beyond cynical. It hurts people. And in the end, it will slow us down from finding a solution. Having said that, Mr. Chairman, I still make a public commitment that I'm willing to work toward the solution when this all blows up. And it will blow up. There's no expectation that this is going to get to the president for signing. This is just a political motivation. I'm disappointed in it. I think we could do better. We are better than this. And to now say that we can't even offer our amendments? Frankly, that offends me. And it ought to offend everybody on both sides of the aisle, because that speaks to what we can expect for the future. And I don't see my colleagues on the other side of the aisle looking with any joy at this point in time. We at least had an opportunity to read the bill, to hear the bill read. And many of you have not read the bill and weren't in the room to even hear it. And we're going to vote on it. I'm sad about that, Mr. Chairman. I yield back.
Gentlelady yields back. Gentleman from New York.
Mr. Chairman, I move the previous question on the bill and the amendment here thereto.
Question is on ordering the previous question. All those in favor say aye. Aye. All opposed say no.
No, Mr. Chairman, a request to recorded vote.
Recorded vote is requested. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Sablan? Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Chicano? Mr. Chicano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. DeSagne votes aye. Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Strahan? Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe?
Yeah, this is ridiculous. No.
Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes no. Mr. Allen? Mr. Rooney? Mr. Rooney votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Muser? Mr. Muser votes no. Mr. Timmons? Mr. Timmons votes no. Mr. Johnson? Mr. Johnson votes no.
Mr. Chairman, how's Mr. Allen recorded?
Mr. Allen votes no.
Clerk will report.
Mr. Chairman, on this vote, there are 25 yeas, 19 nays.
The motion on the previous question is agreed to. The question is now on the amendment in nature of a substitute. All in favor, say aye. All opposed, say no.
No.
Motion, opinion of the chair, the ayes have it.
Mr. Chairman, I request a recorded vote.
Question is on the amendment in nature of a substitute. Those in favor will vote aye. Those opposed vote no. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Sablon? Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. DeSagne votes aye. Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Strahan? Mrs. Strahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Byrne votes no. Mr. Grothman? Ms. Stefanik? Ms. Stefanik votes no. Mr. Allen? Mr. Allen votes no. Mr. Rooney? Mr. Rooney votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Muser? Mr. Muser votes no. Mr. Timmons? Mr. Timmons votes no. Mr. Johnson? Mr. Johnson votes no.
How is Mr. Levin reported?
Mr. Levin is not recorded. Mr. Levin votes aye.
And how is Ms. Omar recorded?
Ms. Omar is recorded as aye.
Okay.
How's Mr. Grothman recorded?
Mr. Grothman is not recorded. Mr. Grothman votes no.
Clerk will report.
Mr. Chairman, on this vote, there are 26 yeas, 20 nays.
The amendment nation substitute is adopted. I now recognize the gentlelady from Oregon.
Thank you, Mr. Chairman. I move the Committee on Education and Labor report the bill H.R. 397 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
The question now occurs on reporting H.R. 397 is amended to the House with a favorable recommendation. All those in favor say aye.
Aye.
All opposed, no.
No.
Opinion of the chair, the ayes have it.
We ask for recorded vote, Mr.
Recorded
Chairman.
vote. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Sablon? Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. DeSagne votes aye. Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Strahan? Mrs. Strahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Byrne? Mr. Byrne votes no. Mr. Grothman? Mr. Grothman votes aye. Mr. Stefanik? Mr. Stefanik votes no. Mr. Allen? Mr. Allen votes no. Mr. Rooney? Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Muser? Mr. Muser votes no. Mr. Timmons? Mr. Timmons votes no. Mr. Johnson? Mr. Johnson votes no.
How is Mr. Grothman recorded?
Mr. Grothman votes no.
Anyone else want to be recorded? Clerk will report.
Mr. Chairman, on this vote, there are 26 yeas, 18 nays.
The 26 ayes, 18 nays, the bill is passed. The chair notes for the record that a quorum is present. Now recognize the gentlelady from Oregon.
Thank you. I ask unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended pursuant to House Rule 11, Clause 2L. I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views.
Without objection, so ordered. We're now, I'm going to ask, we're going to recess to vote, ask members to come back immediately so that we can consider the other two bills that we had earlier today. Committee is in recess. Committee will come to order. Committee will come to order. We'll resume consideration of H.R. 1230, Protecting Older Workers Against Discrimination Act. We have three amendments in the amendment in nature of a substitute. The motion is on the First Amendment offered by the gentleman from Pennsylvania, Mr. Smucker. Adds a finding that nearly all successful plaintiffs will not receive any damages, other payments, or reinstatement, but their attorneys will be awarded fees and costs. All in favor? Okay, excuse me. You want them en bloc? Okay. Motion is that the three amendments be voted on bloc. Is there any objection? Then so ordered. The Second Amendment will be a GAO study on implementation delay, and offered by the gentleman from Georgia, Mr. Allen, and Ms. Fox, an anti-retaliation amendment, removes anti-retaliation amendments to Title VII. Question is on the three amendments to the amendment in nature of a substitute. The clerk will call the roll.
Chairman Scott?
No.
Chairman Scott votes no. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Fudge? Mr. Sablan? Ms. Wilson? Ms. Wilson votes no. Ms. Bonamici? Ms. Bonamici votes no. Mr. Takano? Mr. Takano votes no. Ms. Adams? Ms. Adams votes no. Mr. DeSagne? Mr. DeSagne votes no. Mr. Norcross? Mr. Norcross votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Morelli? Ms. Wild? Ms. Wild votes no. Mr. Harder? Mr. Harder votes no. Mrs. McBath? Mrs. McBath votes no. Ms. Schreier? Ms. Schreier votes no. Ms. Underwood? Ms. Underwood votes no. Mrs. Hayes? Mrs. Hayes votes no. Ms. Shalala? Ms. Shalala votes no. Mr. Levin? Ms. Omar? Mr. Trone? Mr. Trone votes no. Ms. Stevens? Ms. Stevens votes no. Mrs. Lee? Mrs. Lee votes no. Mrs. Strahan? Mrs. Strahan votes no. Mr. Castro? Mr. Castro votes no. Mrs. Fox?
Yes.
Mrs. Fox votes aye. Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes aye. Mr. Wahlberg? Mr. Wahlberg votes aye. Mr. Guthrie? Mr. Guthrie votes aye. Mr. Byrne? Mr. Byrne votes aye. Mr. Grothman? Mr. Grothman votes aye. Ms. Stefanik?
Yes.
Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes aye. Mr. Rooney? Mr. Smucker? Mr. Smucker votes aye. Mr. Banks? Mr. Banks votes aye. Mr. Walker? Mr. Walker votes aye. Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Fulcher? Mr. Fulcher votes aye. Mr. Taylor? Mr. Taylor votes aye. Mr. Watkins? Mr. Watkins votes aye. Mr. Wright? Mr. Muser? Mr. Muser votes aye. Mr. Timmons? Mr. Timmons votes aye. Mr. Johnson? Mr. Johnson votes aye.
The clerk will call the roll of those who have not responded.
Mrs. Davis? Ms. Fudge? Mr. Sablan? Mr. Morelli? Mr. Morelli votes no. Mr. Levin? Mr. Levin votes no. Ms. Omar? Ms. Omar votes no. Mr. Rooney? Mr. Wright?
Record report.
Mr. Chairman, on this vote, there are 20 yeas, 25 nays.
The noes have it. The amendments are not adopted. The next is on the amendment in nature of a substitute. All in favor of the amendment in the nature of a substitute will say aye. Aye. All opposed, no? No. Ayes appear to have it. The ayes have it. Gentlelady from Oregon.
Mr. Chairman, I move the Committee on Education and Labor report the bill H.R. 1230 to the House of Representatives with an amendment in the nature of a substitute,
Final passage.
and with the recommendation that the amendment be agreed to and the bill be amended as amended do pass.
The motion is on reporting the bill favorably to the floor. All in favor, say aye. Aye. All opposed, no?
No.
The ayes appear to have it.
Mr. Chairman, could we have a recorded vote, please?
Recorded vote is requested. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Mr. Sablan? Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. DeSagne votes aye. Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Strahan? Mr. Strahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Byrne votes no. Mr. Grothman? Mr. Grothman votes aye. Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes aye. Mr. Rooney? Mr. Smucker? Mr. Smucker votes aye. Mr. Banks? Mr. Banks votes aye. Mr. Walker? Mr. Walker votes aye. Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Fulcher? Mr. Fulcher votes aye. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes aye. Mr. Wright? Mr. Muser? Mr. Muser votes aye. Mr. Timmons? Mr. Timmons votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Johnson votes no. Mr. Timmons votes no. Mr. Muser votes. Mr. Muser votes no.
You got to start it. Who's the?
Mr. Watkins votes no. Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher?
No.
Mr. Fulcher votes no. Mr. Walker? Mr. Walker votes yea. Mr. Walker votes nay. Mr. Walker votes no. Mr. Allen? Mr. Allen votes no.
Is anyone who has not been recorded or wants to change their vote? If not, the clerk will report.
Mr. Chairman, on this vote, there are 27 yeas, 18 nays.
27 yeas, 18 nays. The ayes have it. The motion to report as amended is agreed to. Chair notes for the record a quorum is present. I now recognize the gentlelady from Oregon for unanimous consent request.
Mr. Chairman, I ask unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended. Pursuant to House Rule 11, Clause 2L, I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views.
Without objection, so ordered. We now resume consideration of H.R. 1309, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. There is one amendment in addition to the amendment nature of a substitute that is offered by Mr. Byrne from Alabama, striking in its entirety and inserts an alternative that removes the interim final standard and sets no date for final standard. Question is on the amendment offered by Mr. Byrne. All in favor will say aye. Aye. All opposed will say no. No. The noes appear to have it.
We have a recorded vote, Mr.
Recorded vote is requested. Clerk will call the roll.
Chairman Scott?
No.
Chairman Scott votes no. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Fudge? Mr. Sablan? Ms. Wilson? Ms. Wilson votes no. Ms. Bonamici? Ms. Bonamici votes no. Mr. Takano? Mr. Takano votes no. Ms. Adams? Ms. Adams votes no. Mr. DeSagne? Mr. DeSagne votes no. Mr. Norcross? Mr. Norcross votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Morelli? Mr. Morelli votes no. Ms. Wild? Ms. Wild votes no. Mr. Harder? Mr. Harder votes no. Mrs. McBath? Mrs. McBath votes no. Ms. Schreier? Ms. Schreier votes no. Ms. Underwood? Ms. Underwood votes no. Mrs. Hayes? Mrs. Hayes votes no. Ms. Shalala? Ms. Shalala votes no. Mr. Levin? Mr. Levin votes no. Ms. Omar? Ms. Omar votes no. Mr. Trone? Mr. Trone votes no. Ms. Stevens? Ms. Stevens votes no. Mrs. Lee? Mrs. Lee votes no. Mrs. Strahan? Mr. Strahan votes no. Mr. Castro? Mr. Castro votes no. Mrs. Fox?
Aye.
Mrs. Fox votes aye. Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes aye. Mr. Wahlberg? Mr. Wahlberg votes no. Aye. Mr. Guthrie? Mr. Guthrie votes aye. Mr. Byrne? Mr. Byrne votes aye. Mr. Grothman? Mr. Grothman votes aye. Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes aye. Mr. Rooney? Mr. Smucker? Mr. Smucker votes aye. Mr. Banks? Mr. Banks votes aye. Mr. Walker? Mr. Walker votes aye. Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Fulcher? Mr. Fulcher votes aye. Mr. Taylor? Mr. Taylor votes aye. Mr. Watkins? Mr. Watkins votes aye. Mr. Wright? Mr. Muser? Mr. Muser votes aye. Mr. Timmons? Mr. Timmons votes aye. Mr. Johnson? Mr. Johnson votes aye.
Clerk will report.
Mr. Chairman, on this vote, there are 20 yeas, 25 nays.
The nays have it, and the amendment is not adopted. Next question is on the amendment in the nature of a substitute ordered, offered by the gentleman from Connecticut. All in favor of the amendment in the nature of a substitute will say aye. Aye. All opposed, no.
No.
The ayes appear to have it. The ayes have it. The amendment in nature of substitute is agreed to. I now recognize the gentlelady from Oregon.
Thank you, Mr. Chairman. I move the Committee on Education and Labor report the bill H.R. 1309 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
Motion is on the motion is, the vote is on the motion to report the bill as amended. All in favor will say aye. All opposed say no.
No.
Ayes appear to have it.
Mr. Chairman, on that, I request a recorded vote.
Recorded vote is requested. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Mr. Sablon? Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. Norcross?
Who did you call?
Mr. Norcross votes aye.
Thank you.
Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Strahan? Mr. Strahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No, no, no.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Byrne votes no. Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes no. Mr. Rooney? Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Walker votes no. Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Muser? Mr. Muser votes no. Mr. Timmons? Mr. Timmons votes no. Mr. Johnson? Mr. Johnson votes no.
Clerk will report.
Mr. Chairman, on this vote, there are 26 yeas, 18 nays.
The 26 ayes, 18 nays, the motion is agreed to. The H.R. 1309, as amended, is ordered reported favorably to the House of Representatives. The chair notes for the record that a quorum is present. Recognize the gentlelady from Oregon.
Thanks. Mr. Chairman, I ask unanimous consent that the committee wish Representative Omar's daughter a happy 7th birthday. And
Without objection.
And I also ask unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended. Pursuant to House Rule 11, Clause 2L, I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views.
Without objection, so ordered. And if there's no further business to come before the committee, without objection, the committee stands adjourned.